Password.
Item number 27.
May I please, on behalf of Mr. Bahadur. My lord, in this case, I have to file an additional affidavit. In the averment, I have stated that some of the voters are dead. In the meanwhile, I have obtained that report from through RTI.
You have not removed the defect, sir.
A translated copy already filed, Lordship, on 3rd of February.
No, there are still 2 defects. What are those defects? So you have to make a representation that you have not complied with that defect. You have to first make a representation, sir.
My lord.
You see, the defects have not been cured despite an adjournment granted for the purpose. The petition is accordingly not entertained and disposed of. That's first off.
Item 28.
My lord, item 28 is the disposal of the representation dated 17 December 2022.
My
But
lord.
You see, the
yesterday
defects have
we
not.
came to know that Collector Bolangir has already disposed of the representation, so we want to withdraw the writ petition. my lord.
Counsel, the petitioner seeks leave to withdraw the present petition, disposed of. Fine.
Item number 29.
Item number 29, your lordships. CMC was directed to obtain instruction, your lordship.
My lord, my instructions are that 34 toilet blocks, each block having 7 seats, have been completed and handed over to the community there. 3 toilet blocks, work is in progress. Watco has already provided individual water connections to each
File an
household.
affidavit, sir. File an affidavit.
My lord,
Mr. Devashish Nayak, learned counsel appearing for the CMC, states that he will file an affidavit indicating the present status of provision of toilet blocks to the community in question. The affidavit will possibly be filed on or before 13th March,
my lord.
an advance copy to counsel for the petitioner. List on 15th March.
My lord.
Deeply obliged.
Item number 30.
In person.
Item 30. WPC 2373 of 2023.
Passover.
Item number 31.
May I please, your lordship?
Yes, please.
My lord, the opposite partner 4 to 12, my lords, encroach the government land, my lords. Kindly have a glance, annexure 6 series, my lord, Tahsildar, pass the order. After heard the matter and pass the order, my lords, kindly see annexure 6 series, page 16, my lords. Date 16/9/2022. Heard the encroacher and he has admitted that he has encroached the above said land. The encroacher is not a landless, homeless, stateless for person, and also the land encroacher is highly
You can appeal
objectionable.
against this. Tahsildar's order is appealable.
That can be appealed before the sub-collector.
Is permitting the petitioner to challenge the impugn order dated 16 September 2022 of the Tahsildar
Bhogarai.
before the sub-collector. The petition is disposed. In accordance with law, the petition is disposed. Right.
Item number 32.
Construction of village road, my lord. The petitioners makes grievance on annexure 4, my lord, before opposite matter 2, my lord. That is pending for dependent. This matter. Construction of village road. Grievance is pending on
Petitioners-
annexure 4.
Representation bracket annexure 4 series
Before
Maybe
opposite matter
example.
2,
by the Tahsildar.
by collector, my lord.
Okay. Collector Jashpur, and after notice to the petitioners and giving them a hearing. The reasoned order should be passed not later than 1st May and be communicated to the petitioners within a week thereafter. The court clarifies it is not expressed.
Item number 33.
My lord, I may pardon my lord for appearing through VC, my lord. My
Yes.
lord, in this case, we have challenged the validity of the Enter Tax Act. In pursuant to the direction of the Honorable Supreme Court, we have filed the writ application, my lord.
When is that coming up, sir?
13th of March, my lord. The
All
back.
right, list on 13th March. All right.
Lord.
Item 34,
34, 39, my lord, entry tax interest matter, after lunch. Copy has not been.
After lunch, all right. 34 and 35,
35, my lord.
all right.
item number 36,
Wait, please, Millards. Millards, so we'll remove the defect within a week, Millards.
21 matters, sir.
Millards,
What's the
there is
matter
a-
about?
Millards, the matter is about we have challenged the demand come show cause notice issued under proviso to section 73(1) of the Finance Act. Millards.
It's only a show cause notice, sir. You can reply to it.
Yes, Millards.
The petitioner has approached this court at the stage of show cause notice. The court is not inclined to interfere. Paragraph, if the petitioner has not already
Millards, but-
replied,
Millards, one
show cause
peculiar,
notice.
Millards, one peculiar point that is involved, Millards. Millards, the entire scenario, factual scenario was within the knowledge of the department, Millards. Millards, but still they chose to issue notice under the proviso to section 73(1). Not under normal section 73, under the provision of 73(1), Millards. Millards, the proviso speaks about the delayed period under which
You can take all those differences, sir. If not already replied to, the reply to the show cause notice will be filed not later than 3rd April 2023. In that event, the adjudicating authority will, after hearing the petitioner, pass the appropriate order on the show cause notice in accordance with law within a period of 3 months thereafter. No further directions are called for at this stage. The petition is disposed of.
item number 37,
Your Lordship, appearing for opposite party number 1 to 4. I'm appearing for opposite party 1 to 4.
item 37,
None appears dismissed.
I'm appearing for opposite party number 1.
item 38,
My lords, 38 GST first appellate order is on challenge, my lords. Lordship,
You have to remove the defects. You never removed it.
my lords, I have given the copy.
Copy has just started.
All right, then the same order. 10% you paid.
21.
What is he already paid?
10% I have paid.
So same order. There is
So the
got a
rest
copy
of the
order.
amount 20%, my lord. Rest of the amount 20%.
Obviously, sir, that's what we pass. Right. We have a standard order, sir. 10%, 20%. List on 4th September.
item 39,
39, my lords, I had challenged the question of jurisdiction. My friend has given me slip that I have registration. Let me permitted to withdraw and file appeal and raise all the questions before the
Counsel,
first
petitioner
appeal.
seeks leave to withdraw the present petition with liberty to file an appeal as provided in law. If such appeal is filed not later than 3rd April, accompanied by an application or delay, citing the pendency of the present petition as a reason for the delay, be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in the matter. Originals be returned subject to substitution that is report of office.
item number 40,
May please, your lordship. I'll remove the defect, your lordship, first. I have not served the copy, your lordship, for the second copy and the copy for the
What
GST,
is
your
annexure
lordship.
1?
Lordship,
What is annexure 1?
annexure 1 is the demand.
So it's challengeable, sir. Seek
Demand, your
appropriate
lordship.
remedies to challenge all this.
Lordship, here the issue is whether the royalty can be, GST can be demand on royalty, your lordship. The larger issue has been referred,
Okay, sir.
larger issue has been referred by Supreme Court and it is pending before the court as instruction I have received, your lordship.
All right.
Then your lordship, then keep, I'll obtain the latest information, lordship, keep it next week, your lordship, for which
Sorry, sir.
the issue is only very small issue, whether the royalty, they are now demanding the royalty on sand mileage, the GST on sand royalty mileage. Earlier I have other aspect already paid mileage. Now the question whether the GST can be the raised on the royalty mileage. That issue is pending before the court mileage.
Yes.
So apex court, honorable apex court, your lordship.
Permitting the petitioner to avail of the alternative remedy available to the petitioner against impugn demand. The petition is disposed of.
item 41,
Same.
Same.
item number 42,
My lord, I have already made the payment of 20%. Against I have challenged the
First appeal order.
All right, same order.
Copy is served.
4th September. All right.
Item 43. My lord, 44 also same.
All right. 42 and 44 same. 43.
43. Item 43.
My lord, dispensing with the annexure 2, your lordships. And
All right.
the
Dispense.
challenge had made to the order of the commissioner of who dismiss my appeal petition, your lordships, non-deposit the pre-deposit of 7.5%. I may permitted to 7 deposit of 7.5% and might be relegated to the commissioner of police, my lord.
Your lordship kindly turn to, I am happy for the opposite parties, my lord.
This is already held by my lords in 2 of my lords' orders.
My lord, kindly turn to page 83.
83.
83, para 3, my lord.
Ah.
3.3.
Hmm.
5 times he has been given an opportunity to deposit the.
I'm not disputing, my lord. I mean, given opportunity to pre-deposit already.
My lord,
Because it's a COVID, there is a infrastructure sector has been totally in a collapsing position, lordship. That's why I couldn't able to pre-deposit, lordships.
it is after the COVID, it is the year of 2022.
Still the sector is not been revived. Still the sector is not been revived, my lord. I'm not getting the merit of the, I'm just trying to make the pre-deposit lordships and let me commissioner will decide on its merits, my lords.
My lord Fed can always appear the approve the sister, and the honorable sister can go into the merit of the case, my lord, even if it has been not touched by the first appellate authority.
%7.5%.
Here 20%, sir. This one says.
No, in case of in the finance, it is 7.5%, your lordships. 7.5%, my lord. Order passed by the Commissioners of Appeal, GST, Central Excise and Customs, my lord.
GST?
Commissioner of Appeals, GST, Central Excise and Customs, my lord.
CGSC. CX is it? What is it called? CX.
Central Excise, my lord.
Oh, so it's now called CX. And customs. Oh, 3rd April.
Deep obliged, my lord.
I have already appeared my appearance memo.
Or right.
Item number 45.
3 metallics.
Same order. I am
Covered.
Lordship have fixed it to 8th of March.
Or
8th of May. Sorry.
May. All right. Same
8th
order.
of May.
All right.
Much obliged.
Again, Mr. Behurauli.
Mera. No, Mr. Behr. I have solved the copy, my lord.
Mr. Behra. All right.
My lord, item 46.
46, my lords, first appeal order under GST Act.
10%, 20%.
My lord.
All right. When is that appellate tribunal going to come? I think they announced in Parliament and all.
We have
Still not.
Yes.
All right. 500 petition. Because the tribunal is not set up. Yes.
46 next day.
4th September, yeah.
Item number 47.
Your lordship may kindly grant a pass over, your lordship.
On both 47.
47 and 48, your lordship, both.
1 minute. Let's just see what it is.
Your lordship?
1 minute. 1 minute. Let's just see what it is.
That is 148.
148 AD.
Order is challenged.
All covered, sir.
Covered to Kailash Kedia's case, my lord. That is-
Kailash Kedia and the other one covered.
Your lordship, my
Lord-
senior will
Senior
appear.
should be here. All
My
right,
lord
pass over.
friend Mr. Acharya was saying that.
I-
That is
anyway.
considered.
Pass over. All right. Same thing.
Highly allowed, your lordship.
Pass over. Item number 49.
49, my lord. As per Annexure 1, during the COVID period on May 2020, my lord, as per the direction of the Superintendent of Excise, my lord, I deposited 15 lakhs, my lord, as a bank guarantee. Thereafter, FL OPSOP was closed for the COVID during the entire year for COVID period, my lord. And when the petitioner applied for refund of that bank guarantee, my lord, the filed counter in this case, my lord, they demanded that there is a shortfall of MGQ, then you have to pay 1,07,92,000, my lord.
So what do you want to
So
do?
far as refund is concerned, my counter affidavit is that he is entitled to, but
He owes you.
he owes this
Ah.
annexure A, B and C. There is no dispute to this. So we have kept it as a security deposit for against this demand of which is around 5 or 6 times to the.
You have to challenge the demand now.
My lord, the entire 2022, my lord, the shop was closed, my lord, for the Janta curfew and during COVID period, my lord. I am not operated, my lord.
That was
That is a considerable point, my lord.
in any case he has to.
Entire the 2022, my lord, from March to the next March, my lord, 2021, my
No,
lord.
no. You are wrong. You are wrong. It was not closed for the entire year. For some months it was closed. Then online sale was allowed. Then home delivery was allowed. Everything was there. There is a notification to that. Only I think 40 days.
Complete lockdown.
Total lockdown. And
What do you want to do?
adjusting that, we have issued the demand notice.
So you have to challenge the demand anyway.
My lord, I have filed against that
No, the petition is for refund, sir. This petition is about refunding bank guarantee. He's now raised a demand. It's running to crores. You have to challenge the demand.
my submission is, my lord, the shop was closed, my lord. The interior area.
My lord, legality of the
challenge the
demand
demand.
cannot be adjudged here in this petition. That is my.
In response to the present petition where the petitioner has prayed for return of the bank guarantee. Refund of the bank guarantee amount. The opposite parties state that the petitioner in fact owes the department
Para 6.
a total of rupees 107,92,883 towards short drawn MGQ against his 3 IMFL shops, which is much more than the bank guarantee amount. Paragraph. Leaving it open to the petitioner to question these demands in accordance with law. The court declines to grant the relief prayed for at this stage. Full stop. While challenging the demands, it will be open to the petitioner to seek adjustment of the bank guarantee amount. The petition is disposed of.
Item number 50.
Item 50, my lord, I pray for the pass away.
All right, pass over.
Item number 51.
My lord, this appeal is filed against the judgment of a single judge holding that the discharge of the probationer after completion of probation period, though found unsatisfactory, he should be given the opportunity of hearing, my lord. And there has been a delay of 94 days. On a defect was a certified copy of the judgment has failed the department.
Delay condoned. Now come to the merits.
Delay of 94 days, my lord.
Delay condoned, sir. Come to the merits.
Your lordship may go to page 5 of my writ appeal, page 10, para 10. In that case, I oppose the writ petition saying that in the period of probation, he had earned 6 misconducts. And therefore,
The minute you say serious misconduct, then you have to hold an inquiry. Or you have to give him a chance.
But
the minute you use those words, serious misconduct.
Giving 1 month salary, but I relied on the apex court judgment in case of Arun Rai, for it is held that for the discharge of probationer, no show cause is necessary, my lord.
By now, you should have completed this whole exercise, sir. Since the impugned order only requires the appellant to comply with the principles of natural justice for disengaging the respondent from service, the court is not inclined to interfere with the said impugned order. The court notes that in the present appeal, there has been no interim order passed. To stop, the appellant ought to have complied with the impugned judgment of the learned single judge by now. So if it is not already complied with, it should do so positively within a period of 3 months from today. The writ appeal is accordingly dismissed.
Item number 52.
None appears dismissed.
Item number 53.
Taken up next week, Lord. 2 defects are there. I'll remove in the meantime.
2020 matters. What is it about?
Yes, Lord. This is a matter of registration of the land has been refused because the petitioner's brother is a lunatic and some documents are required, but without giving any opportunity of hearing, refused to register the land law. And this is the page 31, my lord, that the impugned order in the writ petition. Office of the Servitor Record, the case record is taken up today, cell deed bearing number so executed between the seller Raghunath Mishra and buyer Naresh Biswal. Cell deed is executed in absence of recorded tenant. Raghunath Mishra, the present petitioner. Recorded tenant number 1, Raghunath Mishra, has stated that the recorded number 2, Raghunath Mishra, is a lunatic person. However, he has not provided any proof from which the court can ascertain the veracity of the statement of attorney number 2, Lord.
Sir, all this has to be gone only in the civil court, sir. It's correct. This can be examined only in the civil court.
Not the civil court, Lord, because the...
Who will declare a person to be of unsound mind?
Lord,
that is your contention.
Yes, Lord.
Who will determine that? Who will determine in writ court? The writ court will determine.
No, my lord. The concerned authority will, this, my lord, and without giving an opportunity to prove the document.
These registrars will determine whether somebody is unsound mind. What are you saying, sir?
No, I'm saying that the...
My lord, he has to produce a certificate from the district judge under the Indian Mental Health Act that he is a lunatic person.
Correct.
And he is somebody is his next friend.
Absolutely.
Then only that next friend will be allowed to present the document.
And he said they failed to prove the provided the document. I'm ready to provide the document.
These are not the authorities who can examine all that. The challenge in the present writ appeal is to an order dated 8 September 2020 of the learned single judge, rejecting writ petition civil 9551 of 2020 filed by the present petition appellant, which in turn challenged an order dated 11th February 2020 of the sub-registrar Ira Cole, declining to register a sale deed executed between the appellant and opposite party number 4. Paragraph. A perusal of the aforementioned order dated 11/2/2020 reveals that the sale deed was executed in the absence of recorded tenant number 2, that is Sri Jadunath Mishra. Full stop. The contention of the present appellant was that the said Sri Jadunath Mishra, open quotation, is a lunatic person, unquote. In the absence of any proof of such contention, the registration of the sale deed was rejected. Paragraph. The learned single judge has rightly observed that the remedy of the present appellant lay before the civil court, unless the appellant was able to make good the aforementioned contention made in respect of Sri Jadavnath Mishra by getting a decree from a competent court in accordance with law. The registering officer could not be expected to simply accept such a plea. Paragraph. Consequently, the court finds no grounds made out to interfere with the opinion order of the single judge. So the writ appeal is dismissed.
Item number 54.
May I please finish? So even though
My
your
lord,
lordship,
need some more time to production of the assessment record, my lord.
in fact, my lord,
Yes,
there were
sir.
3 questions which were admitted by your lordships, my lord. One of the question, my lord, is whether component and spare part are one and the same so far as the Odisha Sales Tax Act is concerned. So your lordships were of the opinion that if there is no formation of opinion for a 12-8, because I succeeded in a 12-4 original assessment, then on the basis of the audit report, a 12-8 assessment was taken up, my lords, where they said that component and spare parts are not one and the same thing. So spare parts as such will be were taxed at the residuary entry at 12%, not 4%, which we have paid, my lord. Lord, I won in the first appeal stage, my lord. Then the state went up into the tribunal. The tribunal said, my lord, my lord, with effect from 1/4/2021, spare parts was also included in the along with components. So that's why spare parts cannot be treated to be one and the same as components, my lord. For this proposition, my lord, I just rely on the judgment of the Honorable Supreme Court.
No. That's the. So you're giving up. Then we'll say
No, I am not giving up this.
Then if you're not giving up, then he has to produce a record, sir.
3 months have already passed.
No.
It was 60.
Last opportunity is granted to the department to produce the original assessment record in terms of the order dated 16 November 2022, passed by this court. Full stop. It is made clear that if the record is not produced on the next date, the matter will proceed on merits.
Grateful one.
List on 4th September.
Item 55.
Yes.
Becoming infractions permitted.
All right. Disposed of his infractions. All right.
Item number 56.
My lord, in item number 56, there are batch of cases. All the cases are posted to 27th February. Only in this case, wrongly.
List on 27th. All right.
27th.
Item number 57.
CB Medical College.
Item number 57, my lord. My lord, this is a PIL matter, my lord. Matter relates to disposal of biomedical waste generated not only in SB Medical College and Hospital, but also other 2 government hospitals, that is Bhimsar, as well as the Berhampur KM.
So you visited or not?
Already, sir, visited.
Where is the report?
Already filed affidavit, my lord.
When?
We have filed 2 affidavits, my lord. One affidavit has been filed
30th January, another
30th January, another affidavit has been filed on
1st February.
my lord. It finds less.
So he has to take instructions on both affidavits, sir.
Yes.
An affidavit has been filed by the petitioners on 1st February 2023 after visit to the No, this affidavit has nothing to do with your visit. This 1st February affidavit.
First affidavit in respect of SB Medical College.
No, you were to visit Burla and that other place.
Already I have visited and filed, my lord.
Which affidavit?
Affidavit dated, my lord, 22nd December, my lord. 22nd December, my lord. Which is at page flag 112.
All right. The petitioners filed an affidavit. I think it's 30th January, sir.
30th January, my lord.
You filed, 30th January is the stamp. 30th January 2023 after visiting Vimsar Burla. And two places you have to visit, no?
My lord. Both the places we have visited and filed.
All right. And the MKCG Medical College, Berapur. Stop. The petitioner further filed another affidavit on 1st February 2023.
My lord, that is additional affidavit.
As regards the SCB Medical College, Cuttack. Paragraph. Mr. D.K. Mohanty, learned AGA states that on both affidavits, he will need to take instructions. Paragraph. The court directs that if on examining the affidavits, the authority is required to take corrective action in respect of all three institutions, they should do so forthwith without waiting for orders of this court.
My lord,
paragraph. The action taken on the aforementioned affidavits be placed before the court in the form of a status report by the authority before the next. Realist. April.
My lord,
17th April.
April, my lord. I have got a small submission to be made, my lord. Another affidavit has been filed in respect of SB Medical College, which is at flat 110, my lord.
I've mentioned that. I've mentioned that.
Already mentioned that.
I've already mentioned this.
My lord, oblige me.
Item number 58.
Yes, Mr. Reddy.
58.
You have to unmute.
Hello.
Yes.
Sir, namaste.
Yes.
I have got the affidavit of Commissioner Endowment this morning only.
Oh, I see.
15 pages.
Okay. All right. Mr. Reddy, who appears in person, states he has received only this morning. The further
affidavit after going through it contains 15 pages, in fact.
Or further affidavit of the Commissioner of Endowments. There is
But as far as the affidavit of SI given, it is not in consonant with Bharat 3 of the order dated 11/8/21. The affidavit has been filed by the present incumbent. However, the order it has been directed who has filed the affidavit to clarify this aspect. SI who has filed the affidavit.
All right. Then paragraph. Mr. Reddy points out that in the order dated 11th August 2021, a clear direction had been issued in para 3 to the sub-inspector of police, bracket SI, bracket, open quotation, who has filed the affidavit, unquote, bracket, dated 7th January 2018, bracket. As to the fact regarding filing of final report. Full stop. Instead of the same SI filing an affidavit, the present incumbent appears to have filed the affidavit on
22nd December
2022. Paragraph. The court reiterates the direction issued in its order dated 11th August 2021 in this regard and requires the affidavit to be filed by the same SI positively before the next date.
Sir, one more
Paragraph
point.
rejoinder to the affidavit of the commissioner be filed by the petitioner also before the next.
One more point I want to add, sir.
Yes.
The present condition of the temple is also not in good. Actually, I visited the temple and saw that the boundary walls, etc., are damaged already. And the sanctum also, inner wall also damaged. No proper care has been taken in the meantime.
So you'll have to file an application with photographs. Only then we can ask them to do something, sir.
Okay, sir.
9th May.
9th May?
Yeah.
Yes, ma'am.
Item number 59.
My lord, I am appearing VC.
Yes.
My lord, in item 59, number 1 was to file counter affidavit.
My lord, in this case, the BMC is the main contestant. This is relating to slaughterhouse in Bhubaneswar. And my learned friend has implicated the chief secretary as the opposite party, only opposite party. So necessarily, if he wants a government counter, then the secretary, housing and urban development department, under
You
whom
can ask him too, sir.
your lordship may, because he is not a party. No, no,
right.
your lordship may direct the,
Mr.
because this BMC counter is sufficient for adjudication. That is my responsible submission. This is the BMC. If your lordship direct, then that secretary may be directed to or any of the
Correct. The Secretary, Housing and Urban Development Department, Government of Orissa, will file an affidavit in reply on behalf of opposite party number 1 in reply to the writ petition positively on or before 1st May 2023. Rejoinded to the affidavits, the said affidavit as well as the affidavit already filed by the BMC be filed by the next date. May.
Item number 60.
Lord, may I please, my lord. So, lordship, may I kindly see the last order, my lord.
Item 60.
Last order has not been
Request of
complied.
This time, because I had to elaborate on the commercial vibe. This pertains to, my lords, 2 bridges which were supposed to be constructed, and subsequently, my lords, 1 bridge is being constructed. And
So every time this matter keeps getting delayed and delayed and delayed. Why is that? What is so special about this matter? Somehow I get a feeling that you don't want to take a stand.
No, my lords, we had filed a supplementary affidavit. There was just one.
No, it is out of that supplementary affidavit. We passed that order dated 21st November.
Please. Let me give me a week's time. I'll file my reply.
Last opportunity is granted to the Secretary, Rural Development Department to file the further affidavit clarifying the issue pointed out in the order dated 21st November 2022 of this court. If the further affidavit is not filed on or before 17th April 2023, then the Secretary, Rural Development Department will remain present in virtual mode on the next date. List on 27th April.
Item number 61.
Item number 61, my lords. I am filing this consolidated petition today itself, my lords. My lords, so far regender is concerned, I pray balance 2 days time, my lords.
Mr. Mahapatra states that the consolidated petition will be filed today and rejoinder will be filed before the next date. List on 16th May.
I was fixing it, my lords.
16th May. Item 62.
Yes, miss. All good things have to come to an end, sir.
Yes, my lord.
My lords,
Wait 1 minute, Mr. Samar. Your lordship at the previous occasion asked me, Mr. Mohanty, we have a recording. I have supplied this record. My lordship can see the road's condition. Thereafter, my lord, let's see that whether we are taking steps for
my lord,
everything.
I can straight away tell you what Mr. Samal will say. No, Mr. Samal, even before you say, Mr. Samal is going to dispute what you have said. Correct? Correct?
No, my lord.
No.
My lord, the work is going on, I admit. But my lord, the recording cannot show the wavy condition of the roads. That one can only
Mr. Samal can show that. Only Mr. Samal can show. Let's anyway play the video. He's made that video.
Yes, ma'am.
You know, now, Mr. Mohanty, they make roads on which planes can land.
Yes, my lord.
Can a plane land on this?
That is the road from Raurkela to Jharsuguda, lordship will find. Even if you put a glass on car.
Yes.
Oh, I see.
It is.
So starting from Keonjhar till that.
One stretch of the load, please dedicate it to Mr. Samal.
It's my lord, my lord. Because his effort, my lord, has
That's right. If he had not persisted, he would not have done this.
My lord, some stretches are still not commenced.
No,
At
that is
Salapada, and some stretches are there, my lord. Where is the video of that Salapada? It is not there. You have to show that also, no?
Mr. Samal, why don't you make some videos?
Yes, my lords, I will submit in the next date.
On that trip you take Mr. Montiel.
Yes, 100%. I will take.
Your lordship has directed myself and Justice Sahu has visited this spot.
Right.
And in fact, by that time, almost all are covered.
Let's see how generous Mr. Samal is. Ask him to take
He has
it.
also, he has visited us. He, along with us, he has visited.
That was.
You are from that area, you said last time. You are from that place.
Yes, my uncle's place.
But if your lordship will ask me for my personal experience, now the road is extremely well conditioned. From Pani Koili to Keonjhar, it takes hardly 2 hours, 1.5 or 2 hours. But in
road is
ଭଲ ଗୁରା ଦେଖି
ଭଲ ଅଛି ନା କିଛିଟା କାମ ଆରମ୍ଭ ବି ହେଇନି ନା
ହବ in due course
video
ଆଜ୍ଞା LOI ପୁରା ହଉଛି
This is June 22.
My lord, this is our better condition. Whatever this
my lord, the matter may be taken up next week. I will submit it both sides road का video में आपको दे दूंगा.
It is August 7th.
Up to date.
Or if
Not up to
someone wants to
22.
present a video on the present condition of the different stretches of the highway. At his request, list on.
My lords, I have one more grievance, my lords.
4th April.
My lord, one more grievance I have. My lord, the area, the only poor people reside in the area, apart from the big miners. Those I don't consider. My lord, 3 toll gates in a stretch of 163 kilometers.
That is already
No.
decided by
How?
my lord lordship. That extent, what
My lord, no light का violation हो रहा है.
Mr. Samal perhaps has not seen the latest judgment of Justice Joseph in 2021 has said that it is depend on the whether what is the existence of agency that is decided. If you want to
No
say that,
permanent bridge bypass आप किसी को भी नहीं छोड़े हैं. My lord, 3 toll gate is in a stretch of 163 kilometers. My lord, only 2 gates are permissible. So 1 gate may be stayed, my lords. Then from starting from, my lords, I have filed this petition 7721. From the starting day, I have been pressing the same one and the same thing.
I think toll gate is always for the richer people to affect, who will be affected. The car only,
Now fast tag.
So none because why?
Today, in today's situation, the finance company are giving vehicles to poor people also in EMI. So anybody can go. Not only poor, the vehicle is nowadays not a luxurious item, na? Banojodi, Hasanpur, 3
para 72 onwards, the lordship can see that is
Banojota last. Banojota last, Rimuripur Guru.
para 72 onwards.
So now this must be reported, sir.
I reported, my lord, that is 21. 7 SG, my lord, I reported judgment, I could not vote.
Anyway, you give it to Mr. Samal.
My lord,
Next hearing. All right.
My lords,
4th April.
Item number 63.
Good video, my lord, I will submit.
You take my lord, that my lord will visit the goddess Tarini and thereafter you start standard. I don't have. Make a request at least.
Item 60.
Please, your lord.
My lord is always welcome.
My Lord in front has filed an affidavit.
I have not filed.
This relates to non-execution of the orders of the ORERA and instead of it sending it to civil courts. Now, the affidavits filed by them are completely contrary to your lordship's order, where your lordship directed them to sort out these and file the modalities. Your lordship must see the...
Your lordship's kind, my lord, perusal, my lord. On the first date, when the matter was taken up, lordship may kindly see the order, what is being passed by me.
Para 4 of your lordship's order.
No, may I just please
of September.
May I be allowed to place it, my lord?
All right.
Lordship may kindly see. The grievance of the petitioner is that the orders of the ORERA are not being executed, despite of repeated attempts by those in whose favors orders have been passed. It is submitted that these kind of stalemate frustrate the very purpose of setting up an authority like ORERA. Notice, Mr. Ishwar Mahanti, accept notice, my lord, and then Lord in Counsel for the petitioner draws the attention of the court to an order dated so and so passed by ORERA, Bhubaneswar in execution number case number so and so, in which it states that it is helpless to execute the order for realization of the amount, since it does not possess the power of a magistrate to direct a party to serve a civil prison in violation of the ORERA's order. Mr. Agarwal points out that this is an erroneous understanding of the power of the ORERA under the RERA Act, as it has adequate powers as any other civil court for enforcing a decree. Keeping these submissions, my lord, in mind, your lordship are directed to take specific instruction how the process of execution of the orders of the ORERA can be made effective by ORERA itself. Now, my lord, I have done, my lord, the survey of all the states, my lord, all over the country. I am giving a copy of this, my lord. What my lord and friend through this PIL, my lord, what he wants to achieve is, he wants that lordship to, my lord, enact a law, because
No, you enact, sir.
my lord, the
We
enactment
don't
has
have
already
to-
been done, my
we
lord.
have to.
My lord, may
Neither
kindly
we-
see. My lord, may kindly see. Will you kindly come to my lord, page 3. That's the Central Act, section 40. my lord. Recovery of interest or penalty or compensation and enforcement of order, etc., my lord. If a promoter and a lottery or a real estate agent, as the case may be, fails to pay any interest or penalty or compensation.
Let's look at Madhya Pradesh.
My lord.
Come to page 14 of this compilation. You have a copy?
No, I'll give
let
it.
them.
Here it is. Copy I'm giving. May I take your lordship to Madhya Pradesh, my lord?
Yes.
Rule 27, my lord, recovery of interest, penalty and compensation subject to the provision of subsection 1 of section 40, the recovery of the amount as due as admissible. Land revenue shall be carried out in the manner provided in the local laws, my lord. In this Odisha, my lord, we have the OPDR Act, Odisha Public Demand Recovery Act, my lord.
Read this whole rule, sir.
Then, my lord, comes
Rule 28.
Rule 28. Manner of implementation of order, direction or decision of the adjudicating officers, the regulatory authority or the appellate tribunal, my lord. For the purpose of subsection 2 of section 40, every order passed by the adjudicating officer, regulatory authority or appellate tribunal, as the case may be, under the act or the rules and regulation made thereunder, shall be enforced by the adjudicating officer, regulatory authority or appellate tribunal in the same manner as if it were a decree or order made by the principal civil court in a suit pending therein, and it shall be lawful for the adjudicating officer, regulatory authority or the appellate tribunal, as the case may be, in the event of its inability to execute the order, send such order to the principal civil court to execute such order either within the local limits on whose jurisdiction the real estate project is based or in the principal civil court, my lord.
What is the corresponding Orissa rule?
Odisha rules, my lord. I have quoted, my lord. Also, may kindly come, my lord. To my that compilation, my lord.
Similar, exactly.
Your lordship.
Exactly similar rules.
Similar rule, man.
No, rule 28. Do they have a rule 28?
Yes, sir.
We have the same.
Lordship, for a minute, my lord. Also, may allow me, my lord. Section 40 talks about it. Then, my lord, the next is section 57 of the RERA Act itself. Says that, lordship, got it, my lord, page 3.
Yes.
My lord. Every order made by the appellate tribunal under this act shall be executable by the appellate tribunal as a decree of the civil court. For this purpose, the appellate tribunal shall have all the powers of the civil court. Then, my lord, notwithstanding anything contained in subsection 1, the appellate tribunal may transmit any order made by it to a civil court having local jurisdiction, and such civil court shall execute the orders as if it were a decree made by the
How
court.
many such orders have you passed?
My lord.
How many such orders have you passed transmitting to civil court?
That orders have been passed, my lord, in many cases, my lord. I'll file you for lordships.
In all cases where
Lordship, I have given a details, and state government has also filed a counter, my lord. Lordship, may kindly see that, my
Manoj,
lord.
may peruse the state government's counter. We have given the number of cases execution cases which were before RERA, number of cases which have been disposed of, number of cases which have gone to the OPDR. My lords may take page 3 of my counter, para 6. That ORERA with a letter number so and so intimated the Housing and Urban Department that 228 number of execution cases have been registered with ORERA since its inception, out of which the authority has disposed of 152 cases by 31/7/2022. Out of 152 disposed of cases, 62 cases relating to recovery of money have been sent to OPDR authority for realization. 12 cases have been sent to civil court and 19 cases to OPDR and civil court for execution. 30 cases have been disposed of by ORERA itself without sending into civil court.
What does that mean? I mean, did they get the money or not?
No, my lord, nothing.
No, those 30 cases, let him produce. Those 30 cases.
30 cases.
Produce. You can tell us what happened in those 30 cases.
I'll take instruction. We'll file a
half
what
the
are-
cases.
Yes, so, my lords, only 12 cases have been sent to the civil court.
This is not an achievement, sir. This is a problem.
No, my lords,
The question is 62 money decrees were there. In how many cases of those 62 cases was money actually recovered?
My lord, once they pay the money, my lord, the authorities, after passing the order, my lord, then some of the cases, once you file execution petition, parties they compromise and they themselves withdraw it.
So we don't know.
Statistics
don't tell us anything.
I'll give a statistics, my lord. I'll give a statistics.
We're not able to find out in these 62 cases in how many cases money was actually recovered.
Lordship, may kindly come to page 11 of my counter, my lord.
Para 7 of that affidavit is important, my lord. Next page only of the state government's affidavit. That is most relevant. Para 7. The ORERA has preferred to send only 31 cases out of 152 disposed of cases to civil court for execution. Now, my lord, may see the second bullet point. Creating parallel infrastructure in ORERA for execution of orders will be an unnecessary burden on the state exchequer. Hence, it is fully correct and lawful in part of the ORERA to send its order to the civil court for execution within the local limits of whose jurisdiction it is located or the person is actually reside. It is felt that the ORERA should not have parallel infrastructure to execute its order. But this is completely contrary to your lordship and statute also. Statute says first the ORERA will execute. In case of its inability, it will send. So
Yes,
here
you have
the
done that.
state government has itself created that inability. They are not allowing the ORERA to function. Only 31 cases
may I
required-
point your lordship's notice?
Kindly 1 minute. Only 30.
My lord, file a rejoinder, my lord, so that we will be able
My
to.
lord, I am arguing on facts only.
Why don't you have all the facts with you? You have all the cases with you.
Yes, lordship, may kindly come to page 11 of my counter, my lord. For a minute, my lord.
All right.
This is a counter which has been filed by opposite party number 2, my lord.
Yes.
It starts from, my lord, page 10. That in response to the contentions made in para 4.11 of the writ petition, it is humbly submitted that the allegation against the opposite party that intentionally harassing the home buyers by keeping these cases pending for years together is absolutely false. The filing of cases per year exceeds 250. The disposal by the authorities is keeping pace with the filing. The authority is disposing more than 178 cases per year. The pendency and disposal of the cases year-wise is provided herewith.
Who's talking of that, sir? We're talking of execution.
Execution is there, my lord. Lots of kindly cases filed, all types, is including execution cases.
No, correct, sir. What is happening?
Specific, my lord, I'll give, my lord. Lots of may grant me some time, my lord. I'll do that.
At page 12, the ORERA itself says at page 12 that since these cases are complicated, we are sending it to civil court. My lord, for this very purpose, the ORERA was created. My lord, page 12, 6 lines from the bottom. In view of the complicacy of the execution in those cases, it is felt beneficial for the decree holder to get the desired relief through the civil court, which is better to deal with such matters.
So actually, the point is this. Now it's clear that in 2022, 62 cases involved money decrees. Tell us in how many of those 62 cases money was actually recovered. That's all we need to know. Whether it was recovered by OPDR proceedings or some other proceedings or compromise. Whatever we need to know.
I seek some time, my lord. I will certainly, because
Not a thing. My lord, actually, when ORERA passes an order, there are two types.
My lord,
There are two types of order.
my law enforcement says not a single case. Lots of may kindly see the state affidavit and our affidavit. We have categorically written how many cases we have already been done that.
No. How many cases was money recovered, sir?
Yes, my lord. Lots of may kindly
Sending a matter to the civil court is one. Getting the money actually is another.
They're just acting like a post office. They are just sending it and the matter is gone.
Cases is where Millard's ORERA has disposed of without Millard's taking help of civil court or any other body.
How? This is the whole point, sir. it's so easy to say disposed of.
Your Lordship,
Disposed of because of satisfaction of the decree or not? That's the
my Lord,
question.
we will file a, my Lord, a detailed affidavit. Lordship, may grant me some more time, my Lord, I'll do that.
My Lord, just to show one example, on 9 January 2023, even when this case is pending, now there was a case before the ORERA where a builder had not given the flat since 2017 he was to give. So a person had filed, you complete the construction within so and so period. ORERA in the complaint case passed an order, you complete it within 2 months. He didn't do it, the person filed an execution case. Now even that case, the ORERA has sent it to civil court, that civil court will undertake construction of that building. On the contrary, RERA should have exercised power under Section 8 of the RERA Act and get it constructed through a government agency. But they are completely not applying their mind and sending it to civil court, whatever is coming, every case. Otherwise, Section 26 of the RERA Act says, if the member authority is acting prejudicial to public interest, your Lordship has the right to remove them. Not a single case is being executed, my Lord. The consumer terms are rather better. Under one roof, a person can get executed everything. Here, I have to run to the collector office for OPDR and to the civil court.
It's not that in all cases, one has to run.
So you show us in how many cases
We'll do that.
an order is actually implemented.
Lots of lots.
You see from the affidavits filed both by the state government as well as the ORERA, it is seen that while statistics are furnished about the number of execution cases filed and sent to either the collector under the Orissa Public Debt Recovery Act.
Orissa Public Demand Recovery.
Public Demand Recovery Act 1962 bracket OPDR Act, or the civil court in terms of section 40 and 57 of the RERA Act, read with Rule 26 of the Orissa Real Estate bracket Regulation and Development bracket Rules 2017, it is not indicated whether in each of those cases the orders passed by the ORERA or the ORI Act, as the case may be, have actually been implemented. Full stop. For instance, in the counter affidavit filed by the state government, it is stated in para 6 that by 31st July 2022, ORERA had disposed of 152 cases. It is further stated that out of the 152 disposed cases, 62 related to recovery of money and have been sent to the OPDR authority, that is the collector, that is for realization. Full stop. 12 was sent to the civil court. I don't know what this means. And again, you say 19 to OPDR.
In total, 31 cases have been sent to the civil and the OPDR conjointly. 31 cases.
Anyway. And 19 have been sent to the, I don't know, 62 plus 12 plus 19.
12 plus 19, 12 plus 19.
No.
Please,
Lord, only in 31 cases we have sent it.
All right. It is stated that of the 62 cases that related to recovery of money, 31 have been sent to the civil court and OPDR authority, and 30 have been disposed of by the ORERA itself. Full stop. It is not indicated whether in any of these cases the money was actually recovered. Paragraph. Unless the ORERA is able to indicate how many of its orders have actually been implemented, it will not be possible for the court to appreciate if the procedures outlined in the above provisions for execution of orders of the ORERA are effective. Stop. In order to ensure that the RERA Act serves the purpose for which it was enacted, it will be necessary for the ORERA to be proactive to ensure that the mechanism put in place for execution of its orders actually works and recoveries are able to be effected. Paragraph. Both Mr. Tripathi appearing for the ORERA and Mr. Mohanty appearing for the state government state that they will file further supplementary affidavits after examining the records of the above 62 cases and indicate what the position in each of those 62 cases has been as regards the recovery of the money for which the decree was passed. The supplementary affidavits be filed on or before 1st May 2023. List on 10th May.
The interim, let them not send further cases to civil court because that is really complicating the issues, my lord. The ORERA has sufficient power to execute.
Anyway, let them, this order should give the
your
guidance for that. All right.
Item number 64.
64, my lord, appealable order, man. My lord, your lordships may kindly see the annexure 1, my lord. My lord, initiation of proceeding under section 44 has been initiated by the deputy commissioner. With the deputy commissioner was not delegated with the power for such initiation. Your lordships may kindly see the notification.
This is pending since 2015, sir.
My lord, the effect of the notification is no, my lord. That is the 2009. The commissioner has no power to issue retrospective notification. Your lordships may kindly see page 45.
That's a February 15 notification.
My lord.
Whereas a show cause notice was on 14, January 2014.
14, my lord. My lord, date of effect is there, my lord. No, date of effect, my lord, that is retrospective. Commissioner has got no power to retrospectively effect the notification.
Correct.
My lord has already held that if date of effect, that has to be on Rule 4B, the notification of 2010 and the effect was 1997. The effect was, the court has held that it is from 1997.
No, on the date that you issued the notice,
yes,
there was no such notification, sir. As simple as that. This is all post facto. That won't help you.
On the date of exercise of
suppose you issue now a notification after February 2015 and it pertains to an earlier period, what you say is right. On the date you issue notification, the power must be there, sir. He said the challenge in the present petition is to a notice in form VAT-308 issued to the petitioner under Rule 51(1) of the OVAT rules, no? OVAT rules. Dated 10th January 2014, issued by the Deputy Commissioner of Commercial Taxes, Bhubaneswar 2 Circle. Paragraph. The short ground on which the notice has been challenged is that on the date it was issued, the Deputy Commissioner had no jurisdiction to do so. Paragraph. Enclosed to the petitioner's Annexure 4 is copy of a notification dated 7th February 2015 issued by the Commissioner, vesting the powers and duties of the Commissioner in the Deputy Commissioner. Full stop. Nevertheless, the said notification is not and in fact cannot have a retrospective effect so as to validate the notice issued on 10th January 2014. Full stop. On the other hand, it vindicates the stand of the petitioner that on the date that impugn notice was issued in form VAT-308, that is 10 January 2014, the Deputy Commissioner was not authorized to issue such a notice. Paragraph. Despite the present petition pending, being this present petition having been filed more than 7 years ago and notice having been issued on 3rd July 2017, till date, no counter affidavit has been filed to contradict any of the above amendments. Full stop. An interim order had been passed with this court on that date. Directing no coercive action to be taken against the petitioner, subject to the petitioner depositing ₹5 lakhs within 4 weeks. Full stop. That amount
Yes,
is
my lord,
deposited. Full stop. Paragraph. On the ground that the deputy commissioner who issued the impugn notice dated 10th January 2014 lacked the jurisdiction to do so on that date, so the said impugn notice is hereby quashed. It will be open to the petitioner to seek refund. Any consequential assessment orders bracket and the consequent assessment order bracket annexation 2 and the demand notice bracket annexation 3 are hereby quashed. So it will be open to the petitioner to apply for refund of the amount deposited in terms of the interim order dated 3rd July 2017 in accordance with law.
No, yes, my lord.
The petition is disposed.
My lord, 65 is 10(1) of the Entry Tax Act. ECMAS covered by ECMAS regulations.
My lord was directed to produce the assessment record.
Admittedly, section 10(1) assessment order.
So I don't think Rodi will trace out all these assessment records, sir.
My lord.
Yeah, you say we challenge the present petition is to the reassessment order date 31st March 2017 in form E7 passed by the Sales Tax Officer Baleshwar Circle under section 10 of the Orissa Entry Tax Act 1999. Paragraph. And one of the grounds on which the impugned reassessment order has been challenged is that it was not preceded by an assessment but only by a self-assessment for which there was no acknowledgement by the department, issued by the department. To stop the issues covered in favor of the petitioner and against the department by judgment of this court in ECMAS receipts. Paragraph. In that view of the matter, the impugned reassessment order and the consequential demand notice are hereby quashed. The petition is disposed.
Obliged.
Item number 66.
Memo is taken on record, dismissed, no instructions dismissed.
Item 67.
Under similar matter has been posted to 4th September 2023. It was also yesterday, man.
In that other weekly list, correct. Okay, list on 4th September 2020.
Similarly, another matter 24549 of same case.
Okay, along with 24549 of 2019. All.
Item number 68.
68 needs some more time for counter, my lord. GST first.
All right. Say counter be filed before in 8 weeks, rejoined up the next date. Interim order to continue. 11th September.
Obliged.
Interim order to continue.
Yes.
Item number 69.
69 permitted the withdrawal.
This must withdraw.
Item number 70.
70 and 71 TCS matter. I've given corrected.
All right.
70, 71, both
Yes.
same.
Yes.
But 72 is the demand notice. I'll approach the commissioner with liberty.
All right. Council petitioner seek leave to withdraw to liberty to approach the commissioner. Is it filed not later than 3rd April?
Yes.
Usual order.
The interim order is there. Interim order to continue. I've given order.
All right.
Similar orders.
Right.
Item 73.
Hello, item number 73, the matter has become infectious.
All right. Disposed of is infructuous.
Item 74.
May I please finish? The Lordship's order at flag B may kindly be perused. Here, your Lordships are dealing with the closer as ordered by the Collector District Magistrate Puri, my lords. Lordship would kindly peruse that order, my lords, at flag B.
Yes.
May I just place it, my lords?
Yes.
Heard the learned counsel for the parties, by way of this writ petition, the petitioner have challenged the demand notice dated 745.
Despite no business, MTQ sought to be.
And here, my lord, this particular extract which their lordships have extracted, my lord, is Annexure 3. So by virtue of this common order, both an IMFL op shop and the CS shop of the present petitioner was closed. If your lordship would kindly turn to Annexure 3, my lord, at page 23, my lords. Lordship got it?
Yes.
There your lordship would find that in exercise of powers under 26 of the Bihar and Orissa Excise Act 2015, Mausami FL shop, which belonged to the petitioner where the orders have been passed by the Honorable Court, and Country's Spirit shop at Malun are hereby closed temporarily with immediate effect, my lords. Malun CS shop belongs to the present petitioner, my lords. Thereafter, my lord, Annexure 4 at page 24, my lords. The sub-inspector of excise, my lord, he immediately closes my shop, my lords. And this shop, my lord, was not operating till 9/11/2017, my lords. And this demand, my lord, which is at Annexure, my lords, 5 at page 25, my lord, is for the year 16-17 till the end of February 2017, my lords. So I'd only humbly, on the last occasion, the lordship had directed me specifically to give a order of this Honorable Court, my lord, to Mr. Mahanti. That is by the order dated 9/4/2021, my lords.
Correct. Last
and
order.
my lords. And the
Yes,
same
verify that order, but I think it is a little bit distinguishable because your lordship may kindly have a glance on my counter affidavit, page 3, para 12.
Para 12.
Yes, my lord, page 3. It is humbly submitted that since the petitioner violating the rules opened the shop at the locality which comes under the ambit of Rule 34, he is fully liable to pay the entire government dues as demanded for the shop as per demand notice one. So for the closure period, the demand is not tenable. That is the law laid down by the Honorable Court. But this closure is due to the fault attributable to the licensee. That is the only distinguishing point.
But here, my lord, the same objection was taken in the other case also. Your lordship will appreciate that this shop was operating the same area, my lord, from 2003-4. And Annexure 1 is the license which has been given by the government itself, my lords. They invited objections. They gave me the license by Annexure 1 to my lord at page 16, your lordship would kindly see, with effect from 1/4/2016 to 39/2016, my lords. So now the government can't say that, you know, this is because of me that the shop could not be opened. And there, because of this public law and order situation, exercising powers under Section 26, they closed down both the IMFL op shop operating in the area and my shop also. And the lordships in the other case took up the IMFL case, my lord, and the lordships have passed this order. So in my humble submission, lord, I also stand in an identical footing because in the same annexure, at Annexure 3, my lord, my shop was also closed.
All right. Challenging the present petition is to a demand notice issued by the Superintendent of Excise Puri on 16 March 2017 to the petitioner, demanding shortfall MGQ for the period April 2016 to February 2017 in respect of the petitioner's Malud Country Spirit shop, for which the petitioner held an excise permit. Paragraph. The case of the petitioner is that the petitioner was issued a valid license in respect of the above Malud Country Spirit shop by the excise authorities since 2000-01, which license stood extended for the year 2016-17 by the Collector Puri on 30th September 2016. Full stop. The said license was granted in a lot along with Arakhakud and Kirisahi country spirit shops. Full stop. Paragraph. Within 5 days from the date of extension of the license period for the period 2015-16, the collector and district magistrate Puri issued an order on 13th April 2015 under section 26(1) of the Bihar and Odisha Excise Act 1915, closing both the Malud country spirit shop as well as the single quotes Mausimi FL restaurant on shop functioning at Malud, open quotation, for preservation of public peace. Unquote. The said order notes that it was being issued, open quotation, due to serious objections of local people regarding violation of Rule 34 of Orissa Excise Rules 1965. Unquote. Paragraph. It is pointed out that in respect of the closure of the Mausimi IMFL restaurant on shop and a similar demand raised by the excise department against the license holders of that shop, Writ Petition Civil 8107 of 2016 had been filed in this court, in which a detailed order was passed on 13th August 2019, accepting the plea of those petitioners and quashing the demand notice. Full stop. In the said order, a reference was made to the very same order dated 13th April 2015 issued by the collector and district magistrate Puri, which was common to both the said FL's restaurant on shop as well as the petitioner's country spirit shop at Malud. So in the said order dated 13th August 2019, reference was made to an earlier order dated 23rd July 2019 in Writ Petition Civil 13124 of 2014, Raghunath Sahu versus State of Orissa. The sum total of the above orders was that no demand for shortfall NGQ could be raised for a period during which a shop was closed, not on account of any act of the licensee, but on account of objection by the public. Paragraph. On the previous date, that is 9th April 2021, a copy of the above order was asked to be furnished to Mr. D.K. Manthi, learned additional government advocate, AGA, to enable him to seek instructions whether a similar order could be passed as far as the present case is concerned. Paragraph. Mr. Manthi refers to the counter affidavit filed, where in para 8, it is sought to be contended that the petitioner did not make an effort to shift his shop from the existing site to a single quotes unobjectionable site, and therefore the government should not be made to sustain the loss of revenue. Paragraph. The case of the petitioner stands on the same footing as the FL on shop in Malud, which was also closed down under the common order dated 13th April 2015 issued by the collector and district magistrate Puri under section 26(1) of the BOE Act, paragraph. No, full stop. As already noticed, this court had, by the aforementioned order dated 13th August 2019, and in petition civil 8107 of 2016, quashed the demand raised against the said on shop. Full stop. Factually, therefore, there is no difference between the closure of that shop and the closure of the country spirit shop of the present petitioner, both functioning at the same place, that is Malud. Stop. In either case, the closure was due to objection of the local people and not due to any act of commission or omission of the petition of the license holders. Full stop. The court therefore sees no reason why a similar order as passed with this court in the aforementioned petition, should not be passed in the present case. Paragraph. For the aforementioned reasons, the impugned demand issued against the petitioner by the notice dated 16th March 2017 is hereby quashed. So the writ petition is allowed. No orders is to cause.
So I have a very humble submission. Lords. For the same petitioner, there are two other writ petitions pending for the same area, my lords. May I just pray that is WPC 8105 of 2016 pertaining to the period March 2016 and 5059 of 2016 for the period 2015-16 till February 2016.
May be listed.
May be listed and same orders may be passed.
No, it may be listed. Let me.
Yes, please. Same area, same.
Just note down both writ petitions and say.
I'll give a check.
Next Tuesday. All right.
So Lordship will be calling these two matters.
These two next Tuesday.
Next week.
Greatly obliged.
Item 75.
Ma'am, item 75 on 19(1), Lordship has issued notice. My Lordship has to file a counter affidavit.
Counter affidavit. I have not filed. I pray for a short adjournment. I have passed it.
All right.
There is an intervention.
Lord, I have filed an application for intervention yesterday.
I have to file
That is
objection.
IN number 1570/2023.
I have to file objection to that intervention.
1570.
Lord, that has not come. Yesterday I filed, Lord, that has not come.
See, learned AGA seeks it is granted 8 weeks to file a reply. Order for the next date. Interim order to continue. List on.
But I have solved the copy to both sides.
15th May. All right.
Intervention application I have solved both sides.
I know, but it's not on board, sir.
Yes,
Can pass an order. Okay.
Item 76.
76 made, please, my lord. This is a writ appeal, my lord, challenging the order passed by the Honorable Single Judge, my lord, whereby, my lord, while directing consideration of the application of the respondent for compounding the illegal constructions, the orders passed in the encroachment cases have been set aside. Lordship was also of the view that when compounding is directed, my lord, it will not wipe out the wrong which has been committed, my lord. That Lordship had already heard this matter. But direction was issued to obtain instruction from my learned senior who is appearing for CDM.
May I humbly submit matters. Here in this case, this scheme matters has been floated by the government for one-time regularization. It's not that compounding in an irregular manner, because compounding is so far regular, whereas deviation is concerned, that will be for 10%. Here in this case, kind of a glance to that order matters of the Honorable Single Judge matters. May I place my name?
Yes.
May I place matters?
Yes, please.
Yes, sir. Thing is that matters here in this case, the government floated the scheme for regularization and we are receiving the application for regularization. To consider the application for regularization, not that allow all the applications. And in the meanwhile, we initiated proceeding for demolition. This one-time regularization scheme, once it is allowed, then this portion which gets regularized cannot be demolished. Rest portion, if any matters, can be demolished. So obviously, we have to take a decision on that.
So how many years now? It's 6 years since the single judge passed this order.
Can I have a say in the matter, Lord, if your lordship permit me, with the lordship's permission? I am for OP number 1. But the present petitioners were nowhere in picture, either before the authority or before the single judge. They were not parties to the proceeding, but they simply came and filed this writ appeal before the lordship.
How is that possible?
Is it possible?
Lord, encroachment of public road.
No, you are not a party in the writ petition.
Yes,
You are
Lord,
not
that
a
is why
party.
we have filed an application seeking leave, my Lord. Lordship was kind enough to condone the delay and the leave application is also there.
No, you didn't disclose it.
It's there on record.
Party.
It is there on record, my Lord. I have filed an application for leave, my Lord. That is there on record, right from the date of filing. Lordship was pleased to appreciate that also on the
Where's
last.
that application?
My Lord,
Which-
it is
which
there.
number?
My Lord. My Lord, it is miss case number 243 of 2017.
No notice seems to have gone on that.
My Lord. But in fact, Lordship sees, my Lord, on the last occasion, Lordship was
So
also-
anyway, he's filed that IA. You can't say he did not seek leave.
Without entering into that technicalities, my lords, the application is pending. If he has some grievance, let him raise that point before that authority and let it be decided, my lords, within a stipulated time, my lords.
Only to
I think both
consider
parties
it.
will get-
The direction only to consider it.
But how is it still not considered? There's no
But
stay.
it's
in
not
this.
considered because of the pendency of the writ appeal, my lords, because of the fact
Yeah,
support balance.
pendency. Can't be that, sir.
No, that cannot be, my lords. Fact remains, I bow down, my lords, because of the delay. But fact remains, within a stipulated time of 1 month, we can dispose it of, my lords. Let both the party appear.
All right. Mr. Dayananda Mahapatra, Learned Counsel appearing for the Cuttack Development Authority, bracket CDA, states that pursuant to the impugned order dated 12th April 2017, passed by the learned single judge in writ petition civil 4044 of 2016, the CDA is prepared to hear both the opposite party number 1
Maximum clarified planning member, my lords.
as well as the CDA through the planning member is prepared to hear both the opposite party number 1, respond number 1, we say. As well as the present appellants. In regard to the application filed by, has it already been filed? Has it already been filed, the application?
Application by the respondent is already been filed.
It's
It's pending.
already filed by respondent 1 seeking regularization of the unauthorized construction.
Yes, under the scheme, my lords.
Under the extant scheme of the CDA paragraph, after hearing both the respondent 1 as well as the present appellants, the planning member will pass a speaking order after hearing on a date to be intimated to them at least 1 week in advance. The planning member will pass a reasoned order not later than 1st May 2023.
Yes.
Full stop. It is clarified that the court has not expressed any view in the matter.
Yes.
Right.
The agreed part, it will be open to the agreed party to seek appropriate remedies in accordance with law.
Grateful.
The petition is disposed. Appeal is disposed.
Item 77.
Senior counsel to the appellant is stated to be in some personal difficulties.
If I may, in item 77, my lord, your lordship directed bank to take instruction as to whether the quantum bond is reduced. My lord, I have taken instruction, my lord, because the board is the appellate authority. Therefore, board is going to sit in second week of March. So thereafter, any date your lordship fixes.
Counsel for the bank also informs the court that the board of the respondent bank will consider the matter in the second week of March 2023.
Lordship may fix thereafter, second week, but the third week of March. So that.
All right, third week. List on 16th May.
Item number-
16th May. 16th May.
Yes.
Item 78.
This case, the appellants are the legal heir of a deceased employee of an aided institution. And the petition number 1, this Nirupama Naik, the wife, paid for the family pension. My lord, the effect of the Honorable Single Judge order at Annexure 4. The Honorable Single Judge, by taking note of a government order, denied the benefit to the petitioner. Though under the statute, my lord, this right is available to get. If my husband is a pensioner, then I am to get the family pension.
Who's for the
Kindly
opposite
glance
side?
for the rules. State is governing.
I am appealing.
The managing committee has though noticed, nobody has appeared. The employer.
I am appearing for this school statement.
Who's for the managing committee?
Managing committee
This
has
has
not-
gone there, as my lord's noting says, 80 not back.
Fresh notice to opposite, respond before. That's the addition. List on 10th July.
Item number 79.
May I please? This regarding that UGC matter, let's say page 76 is the 74 is the impugn order. That your lordship is fixed that matter is pending before the Honorable Apex Court. On 14th February, your lordship is fixing other matters to Apex Court.
Stated the matter is still pending the Supreme Court.
On 14th February, it is tentatively decided to come.
It's all right. So adjourn sine die, is that what we say? Which is the matter passed in other orders? I mean, which is the order passed?
Some matters have been fixed to August matter.
Which matters and which date?
I'll provide them. I'll
List
provide them.
on dash along with dash. All right.
I'll provide them.
All right.
Hearing matters. Supplementary list passed or matter item number 26.
Beg your pardon. Sorry.
Item 26. Supplementary list.
None appears despite a password. Dismiss on opposition.
4, item 4 is there.
I think 4 is over.
4 is over.
That Mr. Mahanti appeared.
Oh, I'm sorry.
Item number 30.
Despite a password, the petitioner does not appear. Dismiss on opposition.
Item number 47.
Item number 30, sir. Sir, item number 30, sir.
30. 30.
30.
Item number 30.
You have to unmute, sir. Which is the petition you are
Sir,
appearing?
30, sir.
I
am the petitioner, sir, in person.
Sir,
this petition is to direct Election Commission of India to frame remedies to achieve purity in election that affect due to breaking pre-poll.
They have no such power, sir. The Election Commission does not have that kind of power. They have nothing to do with pre-poll coalition, this, that, all that. Election Commission has nothing to do with that.
And sir, before filing this petition, I requested the Election Commission of India through Gmail letter, which annexed as Annexure A and B with a proposal to issue independent symbol to political party candidates. if
They
are
have no
satisfied
such
to
power, sir.
contest for-
Election Commission has no such power.
Sir, they issued election symbol reservation and allotment order 1968 under Article 324.
What is the relief you are seeking?
I'm seeking to frame remedies.
So they are not legislature, sir. They cannot frame remedies.
But they issued
frame remedy for what?
reservation and allotment order
Frame remedy
1968
for what? Frame remedy for what?
to achieve purity in election which affect due to breaking tribal. Sir, in Bihar and Maharashtra assembly election, tribal alliance formed and splitted after election.
All right. So these are all vague prayers. I think it's better you take proper legal advice, sir. Kindly consult somebody who's aware of this branch of law. Take proper legal advice. All right. It is prayed in this PIL that direction should be issued to the Election Commission of India, open quotation, to formulate norms for purity in election, effects due to breaking three-pole alliance, unquote. The prayer, apart from being vague, is incapable of being granted, as the petitioner has an inadequate understanding of the scope, powers, and functioning of the Election Commission of India. Full stop. He would be well advised to consult persons knowledgeable in this area before filing such petitions. The court therefore declines to grant the relief prayed for. The petition is dismissed.
Supplementary list passed on matter item 47.
May it please, Milots, in these two matters, 47 and 48, Milots, these are covered issues, Milots.
Yeah.
The challenging 148A orders, Milots, Kailash, Kedia and Shiv Metallics, both orders, Milots.
I think in your case, we pass those orders, same order. All right.
Yes, Milots.
All right.
Same order.
All right.
Both, Milots, 47 and 48.
No, not this. Just passed the other day. No. Sir, in your matter, we just referred to both these orders and passed orders. Just the other day, sir. In your own matter, just 3 days ago, we passed an order. Where is that order?
Yes.
Where is that order?
Sheep Metallics case.
No.
In Mr. Acharya's matters, just 3 days ago, we passed orders.
Milots,
Both the Sheep Metallics and
I
don't have it.
Yes.
You also don't have it.
Milots. Yeah, Milots, I'll just. I'm so sorry.
Orders, we passed the same order.
what is the name?
Sorry, Milots.
Mr. Acharya, what is
Hanuman Kedaria, Milots. I will just, Milots, pass it on to the court master.
All right.
I'll just pass it on to the court master.
All right.
Grateful, Milots. I'm so sorry.
Passed on matter item number 50.
Please, Your Lordship. But here the petitioner is running a hotel in the district of Bhadrak, and he filed an application before the opposite parties for grant of license of sale of liquor. It's in his bar, which is located inside the premises of the hotel. But that application came to be rejected, and that is annexure 1, Milots. It's part of 3 series, page 36, if Your Lordship kindly sees. 36, page 36.
Four IMFL on shops are already functioning in Ward 6.
Yes, Lord. But there are 2 reasons on the basis of which it was rejected. First is the distance of the educational institutions being less than 500 meters. So that violates 26C of the Odisha excise rules. And there are 4 other IMFL on shops running in the locality. But this was based on the inquiry report of the excise excise commissioner inspector. And that report I sought for under RTI, and that is page 41. If Your Lordship kindly peruses the next 5. But there it mentions about the distance being less than 500 meters in terms of 26C. But pursuant to receiving this inquiry report, I filed another application for reconsideration before the collector. Now, the collector in reconsideration directed the ADM to conduct an inquiry, and the ADM in turn directed the sub-collector to commit an inquiry. But that inquiry report is annexed to the writ petition. That is page 43, annexure 6. So it's in that inquiry report, Your Lordship permits me to place 2 paragraphs from that report. That is page 43.
So your focus is going to be commuters, tourists, buses, trucks.
That was also the finding of the sub-collector in his report, saying that, and there was a distinction drawn, Millards, because here the other IMFL on shops which operate in the locality in the same ward, but they are basically they are restaurants on the road. But here it's a bar inside the hotel premises. So the interest of the customers is basically going to be the people who reside in the hotel in the rooms and the suites, Millard. But that was the point of distinction also drawn. But if your lordship sees, pursuant to this report of the sub-collector.
This against the order of the collector, he can't go to the secretary.
No, commissioner.
Commissioner, he can go.
That is the impugned orders annexure 9.
Yes, that reconsideration was eventually rejected. But my humble submission is, in terms of the appeal provision in the rules, your lordship peruses 252 for a moment, if your lordships kindly, 252 of the Odisha Excise Rules 2017.
Yes.
That's 251, if your lordship kindly sees, that says an appeal shall lie to the commissioner from any order made by the collector or the additional district magistrate. So here that impugned order is obviously, my lords, appealable. But if your lordship sees the procedure for filing of appeal, the next provision in the rules, every memorandum of appeal relating to cancellation, suspension or withdrawal of a license or pass. But here the rejection doesn't feature. So therefore, my lords, we invoke the jurisdiction of your lordships. But if your lordship observes that I may file an appeal, but they'll entertain probably. But that's my.
No, it amounts to cancellation.
One has to be read with 252.
Yes, but 251, if it's read with 252 minutes, then I have a remedy under appeal.
My lord, it amounts to cancel because his representation for first it was cancelled. Then he represented the collector. Collector cancelled the representation, rejected the that can be appealed under section 252 under rule 252.
You see, Mr. T.K. Manthi, additional government advocate, points out that under Rule 251 of the Orissa Excise Rules 2017, bracket OE rules, an appeal lies to the collector against the impugned order dated 4th August 2022 of the collector Badrak, rejecting the representation of the present petitioner for grant of an IMFL restaurant on license at Moza Mata Sahi under Town Police Station Badrak for the remaining period. This period is over, isn't it? 2021-22.
Well, the period is over, but if I again apply, Millards, these factual aspects will again come into the picture, Millards, because that distance.
If the period is over, then that application lapses.
That's right. No point.
So if I make a fresh application,
we'll ask him to consider it uninfluenced by this.
Millards.
No, my lord, one thing, your lordship, because it will have a precedent. What my respectful submission is that he can file a fresh application anytime for the next.
But that will be considered bereft of the findings.
If another application is filed, again another procedure will be followed from the beginning, from the excise inspector till the government.
No, so it should not be influenced by this report then.
Yes.
Yes.
That's what we said. Paragraph. No, you say, but it is seen that the period itself has come to an end. So at this stage, Mr. Mishra, learned counsel appearing for the petitioner, apprehends that if a fresh application is made for a license, then the impugned order would come in the way of the petitioner's application being considered on merits. Full stop. Mr. Manthi, learned AGA, clarifies that if the petitioner files a fresh application, an application for a fresh license
for the next financial year, then it will be considered independently in accordance with the procedure under the OE rules. That is, by having a fresh inquiry conducted and an order being passed on the basis of the inquiry report. Full stop. The court clarifies that such an exercise will not be influenced by the impugned order dated 4th August 2022 issued by the collector Badrak, which was relevant for the earlier period of 2021-22. Paragraph. With the above clarification, the petition is disposed of.
For hearing item number 80.
On the last occasion, my lord, my learned friend has produced two documents. One notification of the food safety and another the Indian Bureau of Standard. According to him, the manufacturing of packaged drinking water and mineral water is different. But my lord, I visited the shops and collected some labels of the other manufacturers. The first one is of the present petitioner. On the top, my lord, there is ingredients.
Share a copy, Your Lordship.
Yes,
Leonard
yes,
Friend,
yes.
and share a copy with us. But Your Lordship, these documents are not on record. Your Lordship may look at it.
My
but
lord,
these are not on record.
I have to place that whether it comes under mineral water or please packaged drinking water. In Kinley's water, my lord, in the top right-hand corner, my lord, may kindly see ingredients. Added the treated water, salts of sodium and magnesium. And the next, my lord, the other manufacturers, they are also having the same license of the BIS and food safety. They are only writing packaged drinking water, no ingredients are there. Not with minerals or anything. And another document I am producing, my lord, from the e-commerce sites, what they are selling in their sites, my lord. One is of Big Basket and another is of India Mart, my lord. In the heading of mineral water, my lord.
This is the spring water. Mineral water.
Yes, my lord. In the e-commerce site, they are selling it as mineral water, my lord. So it cannot be taken as plain packaged drinking water. And the other manufacturers are also has the same
Mineral and packaging. Correct, correct. Commercial parlance.
my lord.
Your Lordship will kindly turn to the label that we have on record, page 17 of the revision.
Yes.
The Lordship has, it says it's their own order. So it cannot be said that the wrapper says something different. That it does not fulfill the essential conditions to be classified as mineral water. In this context, the dealer too filed a wrapper pasted on the bottle of Kinley, which reads as follows: packaged drinking water. Ingredients: treated water, minerals. Then we specify what the minerals are. Then we say where the minerals we are getting by manufactured by Himjal Beverages, so and so, so and so, so and so, for and on behalf of Hindustan Coca-Cola Beverages, so and so, so and so. In this context, the definition of mineral water in the Oxford Dictionary reads as follows: water naturally or artificially impregnated with dissolved salts. So, Lordship, what we are trying to say is, when we sell it, we are clearly saying it's a packaged drinking water. What we are then specifying is what is added in it. So nobody can be said to not know that this is not a packaged drinking water. The Lordship may then look at the technical specification of BIS that we are handed it over. Your Lordship is well aware, if the legislature, I am in the food industry, Your Lordship, it's a regulated sector. If the BIS tells me to sell something in a particular manner, I'll have to sell it in that manner or not at all. Otherwise, Your Lordship, I will be in breach of the Prevention of Food Adulteration Act, which will be a much bigger risk for me than under the Sales Tax Act. So, Your Lordship may kindly turn to the specification that I had shared on the last occasion, if Your Lordship has, or I can share other copies.
Yes.
Your Lordship has the BIS specification?
Yes. Actually, last time you gave it to us.
That Courtmaster is able to find it. What's your extra copy?
I get it.
We'll hand over the extra copies, Your Lordship.
Extra copy.
Your Lordship, when I manufacture a packaged drinking water or a mineral water, I'll have to follow the BIS standards and the prevention of food adulteration standards. The moment I do it, these are the specifications which I have to ensure that I am in compliance with. Your Lordship will have the BIS standard first. That was in 2004. Your Lordship will come to the 5th page, Your Lordship, Indian standard.
Yes.
Your Lordship has the 5th page, para 3, the definitions. 3.1 is drinking water, which is other than natural mineral water, just like any other drinking water. What I'm selling here is 3.2 packaged drinking water, according to me, which is other than packaged natural mineral water. Packaged drinking water means water derived from any source of potable water, which may be subjected to treatments such as decantation, filtration, combination of filtration, aeration, filtration with membrane filter, depth filter, cartridge filter, activated carbon filtration, demineralization, reverse osmosis, or any other method to meet the prescribed standard and packaged. It may be disinfected to a level that will not lead to harmful contamination in the drinking water. It may be disinfected by means of chemical agents and or physical methods to reduce the number of microorganisms to a level that does not compromise food safety or suitability. It shall be filled in sealed containers of various compositions, forms and capacities that is suitable for direct consumption without further treatment. In case remineralization used, shall Your Lordship may kindly note, conform the requirements of the PFA and the rules framed thereunder. So Your Lordship, the moment I say that I am selling something as packaged drinking water, I will have to do this entire process.
We have a new commodity here called natural mineral water. Now we're not now comparing natural mineral water with packaged drinking water. That's not this case about. This case is about packaged drinking water versus mineral water.
Your Lordship, mineral water means natural mineral water.
The prefix natural. So we're not talking about natural mineral water. We're talking of plain mineral. Mineral water versus packaged drinking water.
Well, Food Safety Act at page 3, they have defined mineral water.
Your Lordship, I'll just show the mineral water definition under the earlier regime also. I have a copy. The one that I shared yesterday. Where's that? Okay. This one. Oh no, this one. You have it? Malot, I only have one copy. I can hand it over. Your Lordship, I have just flagged the relevant pages. Your Lordship will just have a look at it. I will then share it with my learned friend also. If you can hand it over. This is what it was defined under the Bureau of Indian Standards. Your Lordship may kindly see. And it's a definition which has been there since 1998. They keep on revising every year. BIS came up with a new standards in 2004. Your Lordship, I have highlighted the relevant portion. And Your Lordship will then compare it with the subsequent.
Again, the problem here is it's talking of natural mineral water, sir.
Yes, Your Lordship will see there are other kind of mineral waters also which can be then put in the different processes also. It's very similar. Your Lordship will come to the next.
Is only about natural. This entire page is about natural.
Your Lordship, there's only two kind of waters. One is packaged drinking water, the other one is the natural mineral water.
No.
There is no third category.
No, you seem to have introduced. See, the point is by adding minerals,
my lord,
this is what your Kinley label reads.
With minerals.
No, but in with mineral is because there has to be a remineralization process as per the BI standard I had shown earlier. Then prevailing. Your Lordship may kindly read, I'll have to remineralize it up to a certain extent. No one can equate it with a mineral water that is traditionally known as a mineral water, which is a natural mineral water. So there are, Your Lordship, three standards here. Either packaged drinking water or it is a packaged mineral water. How it is to be done, how it is to be packaged, these are all streamlined by the Bureau of Indian Standard and which is looked into by the...
So let's try and understand your argument.
My lord.
You say if it is not natural mineral water, It has to be only packaged drinking water.
Yes, your lordship.
There's no third variation.
There's no third variation, your lordship. Other one is the potable water, which is commonly available.
And both natural mineral water and drinking water have to be packaged. That's
If
that's
you
a
are
compulsion
selling-
here.
Yes, if you are packaging
If you sell either of them, you have to pack them.
Your lordship, if you are packaging it, your lordship may know somebody can sell it separately. I have not come across those instances. But if I'm selling it in a packaged form, then this is the standard or this is the specification which I have to follow.
So this remineralization is part of complying with that standard.
Malos part of compliance, and your lordship knows there are judgments to the effect. If a particular term has not been defined in a tariff entry, which in this case they have not done. There are separate entries here. Natural mineral waters
They
and
have
packaged.
defined packaged mineral water.
It doesn't define, your lordship, anything. It doesn't define anything. So your lordship will have to go into the definition under the statute which governs it. Those line of judgments are there. I can show your lordships. In the classic case of Akbar Badruddin Jivani, similar issue came up when we were looking at import tariff thing. The argument was what you are importing is marble. They said no, it is not marble because what you are referring to is the specifications. As per specification, what I am importing is not marble by virtue of the specifications in India. So there they said that not every time commercial parlance can be looked into. If the statute consciously doesn't define a term, but somebody else is regulated under it, you will have to follow that drill. Similarly, there is another judgment again, where Bureau of Indian Standards specifications or the definition was considered because we are governed by it, your lordship. If today I show it as mineral water and sell it, then food safety authorities will come and ask me, you are selling it as mineral water, tell us how you are complying with BIS or now the FSI. I have no answer to that. So unless it's either packaged packaged drinking water or it is natural mineral water for any commercially prudent person to sell. What my learned friend is showing is labels. I don't know which are of which time or which period. Possibly they are recent ones. Now, what they are not saying over here or how they are not complying with it, we are not aware. We are giving an additional information, and additional information cannot disentitle us. Our drinks are also saying it is packaged drinking water. It doesn't say it's mineral water. If your lordship wants, I can produce those Himalaya and other people, they sell this natural mineral water. They make it clear it is natural mineral water.
From the natural source.
Yes, your lordship.
My lord, that has been defined in food safety, phase 3, what my learned friend has submitted.
Correct.
Mineral water.
Correct.
Mineral water means includes all kinds of mineral water or natural mineral water by whatever name it is called.
No. Where are you reading?
My lord, page 3, that is 2.10.7.
Your lordship, the other specification, FSI that I had handed over, which is the now governing regulation of 2011. The last occasion I had handed over, your lordship.
Yeah, that's zero.
2.10.7 mineral water. Mineral water means includes all kinds of mineral water or natural mineral water by whatever name it is called and sold. They are selling it with minerals.
Manos, may kindly read the entire one. My learned friend is picking up one word and then saying, the what means mineral has been clearly defined.
Yes.
And the processes are completely different from the processes of what we are doing. It's not their case that we are not carrying on the processes that FSI and BIS has specified for packaged drinking water. We are not even saying it's a natural mineral water or even packaged mineral water, so to say.
Actually, if you look
2B, my lord, 2B, it is obtained directly from natural or drilled sources from underground water bearing strata and not from public water supply, for which all possible precautions should be taken within the protected premises to avoid any pollution of or external influence on the chemical and physical qualities of natural mineral water.
No, but it has to be read together.
My lord.
And therefore, lordship will go Roman 2. Again, there is something known as naturally carbonated natural mineral water. Roman 3, non-carbonated natural mineral water. Roman 4, decarbonated natural mineral water. Roman 5, natural mineral water fortified with carbon dioxide from the source. Roman 6, carbonated natural mineral water. Vis-a-vis, your lordship will see the packaged drinking water, there is no such option of any carbonation. It's only the treatment, you'll have to add something in order to ensure it is safely contained and safe for drinking, and you'll sell it.
But I have visited their site, they are showing that they are carbonated this water.
Your lordship, my learned friend is referring to the US site.
No,
Your lordship
my-
knows that unlike in India where we said carbonated drinks are sold as soda or this thing, there it is still water or sparkling water. And their specifications are very different from Indian specifications.
Which year, which is the period we are talking of in these cases?
Maloj?
4-5.
Maloj?
Which period are we talking of in these cases?
4-5. This one is this.
So this anyway, this is 2011, sir. This will not apply anyway.
But I am showing that they have the same BIS hallmark.
No,
And
no, no. We can't.
Now also they are selling this label. In 2000, now at
Sir,
2023,
anyway, we have to stick to 4-5, sir. Tax matters, we can't apply later standards and all. We'll get into a mess.
but I have supplied my lord that
So the label
website.
may be today's
they are-
label. That's why he's correctly asking. We don't know where you got. And if it is today's bottle, we don't know what the bottle was in 2004-5. See, it's a bit unsafe for us to simply pick up the recent label and say we are deciding a case of 2004-5 on the basis of today's label. It's not correct.
In fact, your lordship will see it still says clean drinking water with added mineral. And your lordship is not the one what we are showing. Your lordship knows, we'll Google it. Different sites have their own specification. This is not something which we are advertising. This is big basket. They advertise this in their manner, not something which we are advertising.
It's today's advertisement anyway. So today's, see, we'll clarify one thing, that what we are deciding is for these relevant assessment years. I think that we should clarify. Because each year, sir, what label you use, how you describe your product for marketing, any other purpose, we don't know how you're, yeah. Actually, there's a whole department of product placement, product design, label design. I mean, it's a huge.
They are saying that this purity is from since last
No,
10
that's
years.
what I'm saying. The kind of terms they will use from year to year for improving their marketability, we can't anticipate that. I'm saying we will confine whatever we decide.
My humble submission before my lords is the ingredients. Ingredients column is there with that salt, manganese, mineral is with that water.
No, but there's no. See, if you pick up even ordinary drinking water, packaged drinking water, it will contain some of those minerals, sir. So they will not be misleading in saying it contains these minerals. Whether they've added it or not, that's a different thing altogether. They're only saying, look at this label also. It only says it contains minerals.
But others are not.
No, they're not saying we're adding these minerals.
But the ingredients column is not there. The other manufacturers.
So we are not bothered. We are bothered with them.
Yes, ma'am.
Are they misleading? Are they actually selling something else? That's the question.
But they have the BIS license and the food safety license, my lord, in the wrapper itself.
So I think
that is there.
That's what Eric
we need to clarify that we are deciding it for the years in question.
My lord.
And this can't be ipso facto applied to the later years.
Yes, ma'am.
I think that we'll have to clarify.
Page 17, the extract of that label at that relevant point
Yeah,
of
it's
time,
there.
the assessing authority has
And
extracted
the
what
label clearly
he
says
has-
packaged drinking water. So it's not about an unwary customer not knowing what he's buying.
Absolutely, Your Lordship.
assessing
Your Lordship knows
authority
that
has
those.
clearly extracted at page 16 and 17. That is what he has relied on, you see.
Yes, my lord, I have already seen.
Your Lordship, I'll just hand over those judgments also, which Your Lordship, I'll just have it. You have the copies? Yes. Okay. Akbar Badruddin Jiwari. Akbar Badruddin.
Correct. It's bound to have.
इनका कुछ रूल नहीं था, उन्हें कॉपी दे दियो तुमको। ठीक है।
What they don't tell you is what else it contains.
No, my lords,
The minute they start telling us what else it
my lords,
contains, we won't drink that water.
my lords, my understanding is that this is actually a mandatory requirement. It was at that point of
No,
time.
no, that's right. That it contains all the good elements is mandatory.
And the bad elements they've already removed. Your Lordship will come to para 53 of Akbar Badruddin Jiwani, 12 of 13, page number. Your Lordship has?
Yes.
It is apparent from all these reports that the calcareous stone of specific gravity of 2.5 is not marble technically and scientifically. The finding of the tribunal.
We'll continue after lunch. So after lunch, we'll continue this matter before going on to the part.
Your Lordship will continue at 2 o'clock?
Yes, before going on to the other, we have another part.
With your Lordship's permission, may I mention item number 5 in the weekly list? Could your Lordships take it up in the second week of?
No, all the mentioning for adjournment in the weekly list, we won't take up now. If anyone says, sir, please dispose of this matter in the weekly list, we'll readily take it up. Adjournment, we can always adjourn, sir.
No,
At leisure, we can adjourn.
I was just requesting if your Lordships can accommodate and
if we take up, then we'll talk about it.
because it will come up tomorrow. That's why.
Then this request you can make, if you can ask a colleague also to make that request.
Very well. Very good.
small player, your lordship. Will your lordship take up the yesterday's list?
We don't
Because
know.
there
Sir.
are two matters, heavy
We don't
matters.
know. We
there.
don't know.
Yeah, we may be spared for tomorrow, your lordship.
We'll see, sir.
Yes.
You ask some colleague.
Yes, there will be, sir.
Item 80. Your lordship will have that judgment of Akbar Badruddin Jivani, which I
Mhm.
printed. Lordship will turn to para 53. So this is in relation to whether a stone imported was marble or it's a calcareous stone. In that context, your lordship, para 53 is relevant here. I'll just read out. It is apparent from all these reports that a calcareous stone of specific gravity of 2.5 is not marble technically and scientifically. The finding of the appellate tribunal is therefore not sustainable. It is, of course, well settled that in taxing statute, the words used are to be understood in a common parlance of commercial parlance, but such a trade understanding or commercial nomenclature can be given only in cases where the word in the tariff entry has not been used in a scientific or technical sense, and where there is no conflict between the words used in the tariff entry and any other entry in the tariff schedule. Thereafter, your lordship will come to the fifth line, same paragraph. It starts with the only natural meaning. The only natural meaning that follows from this entry is that entry 62 is confined only to marble as it is understood in a petrological and geological sense and as defined by the Indian Standard Institute, and not as mentioned in the opinion given by the Indian Bureau of Mines on visual observation, and it does not extend to or apply to other calcareous stones mentioned in the ITC schedule. Thereafter, your lordship will come to para 54. Considering all these reports, we are of the opinion that since the term marble has not been defined in the import control order as well as ITC schedule, it has to be taken in a scientific and technical sense as well as in the context of the word has been used, and the slabs of calcareous stones imported by the appellant from Italy cannot be held to be marble as they have not been recrystallized and metamorphized in the geological and petrological sense in the term. Thereafter, your lordship will come to para 56. As regards the submission that the end use of a particular item has to be taken into consideration in interpreting product is of no relevance in determining its classification, as well as we have stated herein above, that in interpreting a term appearing in the tariff item which has not been defined either in the tariff schedule or in the import control order, the same is to be interpreted in such a way which is in consonance with the item specified in the ITC schedule without leaving out any part of the items mentioned therein. In other words, a harmonized interpretation has to be given to each of the calcareous stones mentioned in the tariff, in the said tariff item in ITC schedule, and nothing should be left out or to made redundant in giving the interpretation. The commercial nomenclature or understanding in the trade which is generally given in tax statute cannot be taken recourse to in the instant case in as much as a statutory context in which tariff item appears requires a departure in the instant case. Now, lordship, having read this, what I said is not in every case the commercial meaning has to be looked into. If a particular item has been defined in some other statute also, unless it's been defined under the schedule to the tariff entry, it has to be looked into. Now, your lordship, in that context, may kindly have for a moment the copy of the appeal that has been filed just to see, look what the entries read. Lordship will just have the main revision petition for a moment. Lordship will kindly turn to page 6, bottom of the page.
Yes. Tax-free list.
Tax-free list. We are claiming under item 39, water but not aerated or mineral water sold in bottles or sealed containers. Taxable list, aerated or mineral water sold in bottles or in sealed containers. Lordship, this is no one's case that what is a mineral water or what is not a mineral water has been defined in the statute. It's not defined. Therefore, your lordship will have to look into how the trade or industry or the technical sense looks at. Here, your lordship will have to take cognizance of the BIS standards. BIS standard says there can only be three kinds of water. One is the non-potable water. One, of course, is the aerated water. Third is the packaged drinking water. Third is the packaged drinking mineral water. In fact, your lordship will see the definition of mineral water. A mineral water can be aerated, but a packaged drinking water cannot be aerated. The moment you aerate it, it goes under the aerated category. So, lordship, it's quite clear that the nomenclature as well as what the relevant statute says at that point of time, the product that I was selling, not only commercially I said that it is a packaged drinking water, but there is a specific entry under the statute which says that this is what it is being sold. Therefore, by applying the principle of Akbar Badruddin Jiwani, your lordship will have to see and then decide that the classification will fall under entry 39, not entry 4, as my learned friends are contending. Your lordship, the judgment of Akbar Badruddin Jiwani has been considered by Supreme Court thereafter in Connaught Plaza, though they departed upon it on common parlance, but para 43 of the judgment. Yes. Then let's give a copy to us. Lordship has a copy. Para 43 of Connaught Plaza. Where they consider Akbar Badruddin Jiwani. Your lordship will, your lordship has para 43. Your lordship will turn to the next page. Your lordship, fifth line from the top. Lordship starts at the court examined.
Yes.
The court examined both the entries and opined that item 25.15 referred
This
specifically.
is only summarizing Akbar Badruddin.
Summarizing, Your lordship. Your lordship, finally, in a similar fashion, was another judgment which considered BIS standards and then classified the matter. That was Krishna Carbon, collector of Central Executive, Krishna Carbon. Just one paragraph I show from that judgment, Your lordship.
That is also referred to here.
Maloj.
In Connaught Plaza,
Maloj.
Krishna Carbon is also referred to.
Maloj, lordship.
At para 27.
27. Your lordship, para 11 of Krishna Carbon.
Right.
It is well settled principle of construction as mentioned before that where the word has a scientific or technical meaning and also an ordinary meaning according to common parlance, it is in the later sense that in a taxing statute the word must be held to have been used unless contrary intention is clearly expressed by the legislature. This principle is well settled by a long line of decisions of Canadian, American, Australian and Indian cases. Justice Pollock pointed out in Grenfell versus IRC that if a statute contains language which is capable of being construed in a popular sense, such a statute is not to be construed according to the strict or technical sense of the language contained in it, but is to be construed in its popular sense, meaning of caused by the word popular sense that which people conversant with the subject matter, Your lordship may kindly note,
yes,
with which the statute is dealing with, attribute to it. The ordinary words in everyday use are therefore to be construed according to their popular sense. The same view was iterated by a Story judge in 200 Chess of Tea, where he observed that the legislature does not suppose our merchants to be naturalists or geologists or botanists, but there is a word of caution that has to be borne in mind in this connection. The words must be understood in popular sense, that is to say, these must be confined to words used in particular statute, and then if in respect of that particular sense an artificial definition is given in the sense that a special meaning is attached to particular words in the statute, then the ordinary sense or dictionary meaning would not be applicable, but the meaning of that type of goods dealt with by that type of goods, that type of market should be searched. In the instance case, we have all kinds of papers, including papers subjected to coating, impregnating, etc. If there is a market meaning or trade meaning of that kind of paper, that should be added to. In this case, there is no direct evidence how these peculiar goods are dealt with in the particular market dealing with those goods. But there is evidence how these are to be understood in the light of, Your lordship may kindly note, specifications of Indian Standard Institute, which we have mentioned before. It is instructive to refer in this connection to the passage of the tribunal's decision in Coors India, where the tribunal observed that on the point where the carbon paper is understood as a quoted paper in trade, there is authority of the Indian Standard Institute's publication, glossary of terms used in paper trade and paper industry. Therefore, understood in the accepted notion of construing entries of fiscal statute, not from a technical or scientific point of view, but from the point of view of the people in the trade dealing with that particular type of goods and having regard to the evidence of the Indian Standard Institute, in the absence of any other evidence to the contrary, the tribunal was justified in holding that the basis of definition of paper, as it was in the year 1976, would come within the meaning of 17.2 of tariff item. So Lordship, it's been clearly defined. Therefore, those meaning has to be taken. If there are two contrasting or three contrasting entries, but there are only two entries, but there are 3 or 4 contrasting products which will fall separately, then clearly the definition given under the statute would governs it, which in this case is BIS, has to be considered, Your Lordship. That's our submission.
My Lord, on the last occasion, I had also showed page 47 of my revision petition, what my learned friend suggested that mineral water contains aerated. That 47 is the DIC certificate, my Lord. And what he produces, that is there, my Lord. Aerated water. Yes, it's the normal water, my Lord. That entry is also.
No, you can't shift from one to the other, sir. The tribunal notes it's packaged drinking water.
Yes, ma'am.
I don't think it's your case or anyone's case, it's aerated water. Aerated water is very different, sir.
No, it has to be aerated. What my learned friend has said, that mineral water must be aerated.
No. Aerated is carbonated water,
Yes,
sir.
yes.
Mineral water is not carbonated water. Where do you get that?
For purification, aerated is necessary.
No, not necessary, sir. You're completely mistaken on this. It's a third category: aerated water, packaged drinking water, natural mineral water. These are the 3 identified categories.
My last
aerated water in common parlance is soda.
My Lord.
We are not talking of soda at all in this case, sir.
Yes, ma'am.
Completely mistaken on
That effort, I didn't press that judgment, Your Lordship, of Nalvia Industries, which clearly says that aerated water is soda. So to say, it is not mineral water.
Correct.
Well, my last submission would be that the notification and the Bureau of Standards, as per my learned friend, that from 2004 and 2001, same standard has been used.
All right. Orders reserved.
My Lords.
All right.
Your Lordship wants a written submission.
Yes, you can.
Your Lordship,
Parties are permitted to file.
A week's time, Your Lordship.
Yeah, the written notice submissions. I think 3 days is enough, sir, for you.
So Your Lordship, I'm traveling for the next 2 days. That's the reason I'm
all right, within a week. All right.
Deeply operational.
All right.
Deeply.
All right.
Special list for hearing item number 1. WPC 13736 of 2017.
May I proceed, Lord?
Yes. Good afternoon.
Good afternoon, Your Lord. Lordship, may be pleased to have this Odisha entry tax manual for a second, Lord.
Yes.
Kindly have section 3, my lords, the charging section.
Yes.
There shall be levied and collected.
Yes.
There shall be levied and collected a tax on entry of the scheduled goods into a local area of consumption, use or sale therein at such rate not exceeding 12% of the purchase value of such goods from such date as the state government may specify, and different dates and different rates, etc., may be specified for different goods in local areas subject to such conditions. Now, Rule 3, Your Lordship, may just note, my lords, not pertinent to our case, prescribes the rates, actual rates. But what is important is that this rate is to be applied to the purchase value.
Right.
And purchase value, my lord, is defined in section 2J.
Yes.
Means the value of scheduled goods as ascertained from original invoice or bill and includes insurance charges, excise duties and countervailing charges, sales tax, value added tax, or as the case may be, turnover tax, transport charges, freight charges, all other charges incidental to the purchase of such goods. The object of drawing your lordship's attention is to show that the charging section makes it clear, my lord, that what is the rate along with the rules, what is the rate of tax, when it becomes chargeable, and on what it is to be payable.
No ambiguity.
And no ambiguity on that. Now, kindly come to section 7.1. Every registered dealer. Your Lordships have this from section 7?
Yes, please. Yes, please.
Every registered dealer and every dealer who is liable to get himself registered under this Act shall furnish every month to the Commissioner a return in such form by such date as may be prescribed, and shall furnish along with the return satisfactory proof of payment of tax payable by him under this Act. So, my lords, leaving the proviso for a second, my lords, every month the tax is to be paid. And the tax is to be paid. Along with that, you have to furnish the proof of payment also.
Right.
So section 7.1 is a provision which indicates self-assessment. You have your invoice, you know the rate, you know the purchase value therefore, and you calculate, and according to the return which you are filing. So this is self-assessment. The payment, the liability to make the payment is based on self-assessment. It's nothing to do, my lord, with the subsequent scrutiny or demand or assessments which may or may not happen. The reason being, my lord, that this self-assessed return and payment can well be accepted by the authority, in which event there will be no subsequent assessment, etc., and that matter will stand closed for that particular month. So it's a self-assessment provision here. Now the proviso, my lords, the first proviso, or the only proviso, that a dealer who files quarterly return under VAT Act may furnish return under this Act every quarter. So it has to be either monthly or quarterly, but it is self-assessed. And the proof of payment is to be furnished with the return, which then is to be accepted, lords. Now it is in this context, lords. Kindly see subsection 10. Each and every return in relation to any tax period furnished by a dealer under this section shall be subject to scrutiny by the assessing authority to verify the correctness of the calculation, application of correct rate of tax and interest, claims of deduction, if any, and under this Act, and full payment of tax and interest payable by the dealer for such period. So it's only when on the scrutiny, my lords, it is not accepted, then the question of assessment, etc., would arise, not before that, lords. Now, before I come to 7.5, please turn to section 9, which is self-assessment.
Yes.
Subject to the provisions of subsection 2, the amount of tax due from a registered dealer or a dealer liable to be registered under this Act shall be assessed in the manner hereinafter provided for each tax period or periods during which the dealer is so liable. If a registered dealer furnishes the return in respect of any tax period within the prescribed time and the return so furnished is found to be in order, it shall be accepted as self-assessed, subject to adjustment of any arithmetical error apparent on the face of record. So therefore, the first stage is the stage of self-assessment, and in the present bunch of matters, we are concerned, my lord, with largely, my lord, with self-assessment cases. That's the point, my lord. Now, where, my lord, the assessment is required and the self-assessment is not accepted, then there is to be, my lord, under section 9B, 9C,
scrutiny,
your lordship find, there will be assessments.
Correct.
Whereupon, if there is some changes happening, my lord, if the demand has to go up, then, my lord, demand will follow under section 11. Now, coming back to section 7.5, it is in this context, my lord, we have to see, my lord, how we understand section 7.5, because that's the crux of the question.
Yes.
Where a dealer required to file return under this section fails without sufficient cause to pay the amount of tax due as per the return. This expression is significant. Amount due as per the return. For any tax period or fails to furnish return, such dealer shall be liable to pay interest in respect of so and so. And the rate is prescribed at the end. So there are two aspects of this section 7.5. One is that he should fail to pay. And the other is without sufficient cause. Now, if, as the Lordship saw in JK Synthetics and Food Corporation and this Your Lordship's judgment in Bajaj, they were really cases where the High Court had set aside the liability itself. And in some cases, the judgments had not been challenged before the Supreme Court. And later on, when the judgment is reversed, then the liability revives. So they use the term eclipsed in such cases, that until it is reversed by the higher forum, the tax liability itself is eclipsed. So there is no failure at all. You can't say that he has failed to pay because there is no liability. Now, in the instant case, when I'll place the interim orders and the judgments, then I'll point out that in this case, after the Supreme Court stayed paragraph 30, the liability was very much alive. The act was all through valid. The returns had to be filed. Only, my lord, a workable arrangement had been made that for the time being you pay this much amount. So the question is, this is not a case where there was any eclipse. If at all one may say there was some sort of eclipse, then it could be as during the period when the High Court in 2008 delivered the judgment, I think it's 28 to 2008, it said, unless the goods are produced in Odisha, you can't charge.
Mr. Dwivedi, at the time when these interim orders were passed,
yes,
I think nobody was on ready illusion that the liability had not revived. See, merely granting of stay would not have revived the liability. In fact,
if para 30 of the judgment,
I think it's better you actually read the order and then we can understand the submission. You better read the interim order.
Yes, I will, Lords. But I was just trying to expound how to understand.
No, that is after reading. Once we read, the clarity will be more, at least for us.
All right, Lords, I'll do that, Lords. But may I just say what I want to, Lord, submit how I understand 7.5, Lords. Then, so that, Lord, it all depends on the understanding of 7.5.
Yes.
The question is, Lords, what do we mean by without sufficient cause?
Yes.
My submission is that firstly, an interim order making an arrangement of payment by itself, Lords, will not in any case amount to a sufficient cause, because interim orders are always passed by the courts on an application moved by the petitioners.
No, Mr. Dwivedi, I think the way we understood their argument is slightly different.
Yes.
They were not tracing their sufficient cost to the interim order, sir. They were tracing the sufficient cost to the High Court order, High Court judgment.
Yes.
The High Court judgment relieved them of a liability that provided the sufficient costs not to pay.
So, Malad, if that is so, Malad, then I don't need to labor on this. If my learned friends are just basing on the existence of liability, continued existence of liability after High Court judgment, then I will deal with that, Lord. But as I understood, Lord, it is also their claim that there was an interim order passed,
No. In fact, I think the argument was that the interim order balanced out both. It put you also on terms. In fact, Correct. They said it put you on more onerous terms than it put the petitioners. You had to pay interest if you lost. The petitioners did not, at least Supreme Court at that stage did not say when the petitioners lose, they will pay interest. In fact, in that context, they understood the interim order as actually not permitting you to simply say the liability is revived.
So I will deal with that submission. So what I am submitting with respect is not that an interim order, howsoever stringent its phraseology may be, and irrespective of the terms and conditions of the interim order, that interim order by itself per se can never be a matter of sufficient cause, because a sufficient cause.
It's the other way around, Mr. Dwivedi. That interim order which you obtained, let's be clear, you came to the Supreme Court.
Both sides went to the Supreme Court.
Sir, we are now on your appeals in the Supreme Court in which an interim order was passed.
No, that's perfectly all right.
Mr. Dwivedi, are you seriously saying that you were not aggrieved by the High Court's order?
I was.
So you wanted to avoid the consequence of the High Court order and you sought a stay.
So, my lord, there are two orders passed, your lordship noticed. The first order was passed on our application, on our request, when the sentence obstructing us from recovering was stayed, para 30 was stayed.
Correct.
And then in 2010, my lord, we were
all that it was only an interim order. In fact, the argument you're making actually goes against you if you're going to say, after all, it is only an interim order. Precisely.
No,
after all, it's only an interim order. It cannot revive what has been struck down.
No, I'm saying something else, brother. I'm saying that the first
Mr.
interim order,
which is why I don't like to interrupt. But for my own understanding, I would prefer reading the interim order before discussing the interim order.
as your lordship please, I'll proceed that way.
Yes, yes.
Kindly have the repetition, Lord.
Yes.
And before that, the interim orders, kindly have the judgment, my lords, for a second, of the High Court, 2008.
Yes. It is at page 83 of the brief, Your Lordship.
Yes, yes.
No, I'm referring to the judgment dated 18/2/08.
Correct, sir. Correct, correct.
That is.
Kindly have paragraph 2 first.
Yes.
That's the matter when the matter challenge to the recovery of entry tax under the 1919 Act began.
Right.
While deciding the cases, that's in the first round, the division bench of this court relied upon various decisions of the apex court, including the decision in Bhagat Ram, Rajiv Kumar, and so-and-so. Some of the writ petitioners of those writ petitions preferred SLP before the Honorable Apex Court, which was converted into civil appeal, which was initially taken up along with civil appeal number 3453 of 2002. Messrs. Jindal Stainless Steel, and so as the two judges bench of the Apex Court doubted the correctness of the views expressed in Bhagat Ram, Rajiv Kumar, which was relied upon in subsequent decision in State of Bihar versus Bihar Chamber, matters were referred to larger bench. So I am referring to paragraph 2 only to point out that in the first round, this High Court will not upheld the validity of the Act, and the complete liability was therefore in force. And then when the matter went up to the Supreme Court, my lord, then this issue began, my lord, whether Bhagat Ram is correct, not correct, matter went to Constitution bench. Now, with this, kindly come to the last part of this judgment. Paragraph 30 at page 83.
Yes.
The state has taken the plea that Odisha Entry Tax Act has been enacted under clause A of Article 304 of the Constitution. Therefore, As discussed above, no tax can be imposed on those goods imported from outside the state which are not manufactured, produced in the state of Odisha. However, we do not find any discrimination in the provisions of the Act between the goods imported from outside the state and those manufactured or produced in the state of Odisha and are brought into the local area within the state. In this regard, the definition of entry of goods given in clause D of section 2 is relevant, which shows that there is no discrimination between the goods produced or manufactured within the state of Odisha or imported from outside and are brought within the local area. The rate of tax imposed under the Act or the rules are also applicable uniformly on the goods imported from outside or goods manufactured within the state which are brought into a local area. Therefore, it cannot be said that the Odisha entry tax is not made under clause A of Article 304. However, the state has no jurisdiction to impose tax on the goods imported from outside and are not manufactured within the state of Odisha. Therefore, the opposite parties may make scrutiny of the same and not realize entry tax on such goods. But for this, the Act cannot be declared ultra vires. So the Act has been upheld as valid. Only there is a rider, my lord, which prevents the state from realizing tax under this Act from those of the petitioners, my lord, where goods are not being manufactured in Odisha. That's the effect of this judgment. So the jurisdiction to recover has been held to be not covered by the Act. Now kindly come to the first interim order, which is on RSLP. This is on 30th October 2009. And kindly come to page 92.
Yes.
Towards the middle, you all should see. Pending further orders, there shall be the stay of the impugned judgment till further, no stay of the impugned judgment till further orders in terms of prayer. I'm sorry, Lord, there shall be stay of the impugned judgment till further orders in terms of prayer clause A. To the extent held in para 30, it should, I don't think it's a 30, it's a mistake.
Correct.
Which reads as under, the state has no jurisdiction to impose tax on such goods imported from outside and are not manufactured within the state of Odisha. Therefore, the opposite parties may make scrutiny of the same and not realize. So this portion has been stayed. Therefore, my lord, the effect of the stay will be that they will.
Please continue reading, sir. Continue.
In the meantime, this group of Odisha matters is adjourned for a period of 3 weeks. It is made clear that the state will submit the cutoff date for the simple reason that this court intends to record that each and every SSC in this group of cases shall pay the outstanding amount as of cutoff date in installments within the time fixed by this court. Secondly, it is also made clear that if the state ultimately loses, it shall refund the amount with interest which shall be fixed by this court at the time of final hearing of these matters. However, each and every SSC in this group of cases shall undertake to pay the outstanding amount in installments with the current liability that may accrue. Pending disposal of these leave petitions, it is further made clear that the SSC in this group of cases will have to deposit outstanding taxes without penalty. So therefore, my lord, this is very clearly reviving the liability to pay. And is saying...
That's your submission. We've noted that. We've noted that.
So my submission is that not once, my lord, that offending portion, I'm using this word offending, my lord, with which we were aggrieved. That sentence, once that is stayed and the act remains valid, then first submission is that in view of this interim order, the liability will arise with full force. And
So
Supreme
you make
Court,
no distinction. So, Mr. Dwivedi, as I understand, you make no distinction between an interim order which stays something and the final order which reverses it, right? You make no distinction between the two.
no, there may be distinction in the sense that the final order can reverse or alter the
No,
situation.
no, I'm saying, let's see an interim order staying and a final order reversing.
Well, supposing
According to you, the effect is the same.
yes, let me put it like this and take an illustration, my lord. Supposing the High Court strike down the act, my lord, and the Supreme Court stays the judgment of the
No,
High Court.
let's look at a money decree situation, sir. That's an easier example. Under a decree, X has to pay wife 10,000 rupees. Right?
Yes.
The minute X goes to the Supreme Court, prays for a stay, and the Supreme Court says you better deposit 10,000 rupees. In that case, there will be no enforcement of the decree. According to you, it is amounting to reversing the decree.
No.
No, let's understand. Then
Yes,
finally, when the court reverses, affirms the decree, you will say it's the same. Or reverses the decree, you will say it's the same.
In each case, it will depend what kind of interim order has been passed by the higher court.
No, I'm taking this money example because this ultimately boils down to money. This whole case boils down to money. Do they have to pay the interest? Do they have to pay the entry tax? Ultimately, it's money. These are all in forms of money decrees, sir.
Because it's slightly different than an ordinary money claim, because here the liability to pay tax is statutory. This
Let's
court,
say in all statutes, sir, ultimately money has to be paid.
so this court will not put a particular construction
Which
on
is why, sir, in all tax matters, and you've argued maybe millions, in all tax matters, you insist if you're appearing for the state, sir, let them furnish bank guarantee for 50%, 50% let them pay. It's all money. We pass those orders every day. We say you better deposit 10% or you deposit 20%. It's money.
So it's a workable arrangement in every case which the court
Ultimately,
makes
it's money.
by virtue of interim
Ultimately, it's
order.
money. So,
Yes.
equating, it is in this context, you will have to argue, as I understand you arguing, sir, the stay order and the ultimate order are one and the same, as long as it is in my favor.
May be same, may not be same.
That it can be same itself is an argument.
The final,
It may be same itself is an argument.
No, the final judgment, my lord, will be governed by what sort of judgment, my lord, the court, how it phrases the judgment.
No, that's true. I'm only on how does one understand an interlocutory order? How does one understand a final order?
Yes. My lords, an interim order, as long as it is operating, my lords, it operates to the full extent to which the court intends. Here, the court clearly intended to stay that part of the judgment which required the goods to be produced in Odisha. That portion was stayed, and that related to interpretation of Article 304A. It had nothing to do with the Act. It was the interpretation of 304A, which was construed by this court to mean and imply that the goods can be taxed coming from outside can be taxed only if they are similarly produced in Odisha. On a consideration, my lord, the court on the very first day stays that aspect. So Article 304A, as construed by this court, to that extent was stayed.
So you're not willing to say, sir, it was stayed subject to the final judgment of the Supreme Court. According to you, the minute it was stayed, it was as if there was no High Court judgment at all.
No, High Court judgment is very much there because only one sentence is stayed.
No, sir. We are only on that sentence of the High Court. You are saying, sir, the minute that sentence of the High Court got stayed, that sentence of the High Court got obliterated. That's your argument.
No. It will be an abeyance.
There has to be a difference between something getting obliterated and something being placed in abeyance. That much now you're prepared to concede.
No, I'm saying, my lord, that I'm on the effect of that stay, my lord. I'm not on the words used, my lord, the phrases used. I'm on the question of the effect of this interim order.
Right. According to you, the effect of the stay is to obliterate the sentence in the judgment.
Let me put this illustration to myself, my lord. One more question to myself. Now, supposing, my lord, the Supreme Court had not made a workable arrangement of payments, whether 1/3, 2/3, or some fixed amount, different kind of arrangements were made in different cases by the Honorable Supreme Court, including where in Punjab, Haryana, where they act was struck down completely. Now, supposing that arrangement was not made and simpliciter, my lord, this paragraph, this sentence had been stayed by the Supreme Court. Had the Supreme Court stopped at saying that this sentence in the judgment of the High Court is stayed,
Sir, had it
would
done
they be
that,
liable then, my lord, to file the return and pay the tax under the Act?
therefore, sir, the implied sentence of all such orders is that everything then will be subject to the final outcome. That is the implied sentence, which no court needs to say repeatedly. Everybody understands that all things done in the interim, all these things are done in the interim is subject to the final order.
I have no problem with this, my lord, but I am submitting, my lord, that if
And
the
that final order, as you rightly pointed out, sir, the final order can go this way or that.
No, so therefore, my lord, it cannot be said that until the final order is passed, there will be no liability. That's the point.
It will be subject to, sir. This is the whole point. It will be subject to the final outcome.
So the liability which arises will be subject to the final outcome, and if the
Correct. Exactly. So now coming back to sufficient costs. This is the whole question here, sir. Sufficient costs.
So,
see,
Your Lordship,
we are ourselves having to read this particular interim order so many times to understand its true purport, correct?
So
you're going back and forth, tossing this sentence, that sentence. So let us look at it from a point of the person who has to do this entire exercise of paying.
I'm submitting that an interim order which is passed at whosoever's behest, ultimately, Lord, the interim orders do not result in being a basis for sufficient cause under Section 7(5). That is what I wanted to submit when Your Lordship asked me to come to the interim order.
But that's the only, that's the central point of this entire batch of cases, sir.
So that's what I'm trying to, my lord, if Your Lordship gives me an opportunity, that's what I'm trying to, my lord, support my submission by some certain judgments and all, my lords, that the sufficient cause has to be a cause which is extraneous to the parties' volitions.
Yes.
So my first submission with regard to the first interim order is that the moment, my lord, this interim order was passed, the court intended that the liability should arise, and that they leave no doubt about it when they say that ask the state to furnish the lists so that
All right. Mr. Dwivedi, let me put it slightly differently now. This may help you strengthen your argument if you so wish. Let us say that under the interim order, I am supposed to pay, let's say, 50% of my liability, correct?
Yes.
Here it says installments. In some other case, it says 50% of the liability.
Right.
Now, despite this interim order, there is a failure to pay. Either I don't pay the installments, I don't pay 50%, instead of paying 50%, I pay 20%. I default in complying with the condition of this interim order. Then there is no sufficient cost. Then what you argue is perfectly right. Sir, they had an interim order. It was a conditional interim order. They were required to obey the interim order. Knowing very well what they were required to do, they still disobeyed the interim order. Now, how can they argue sufficient costs? Perfectly valid argument. No problems at all on that. Or, sir, they were supposed to pay 50%. Look, they ended up paying only 30%. They ended up paying 10%. They were to pay it by 1st January. They paid it only in 10th December or something like that.
So that will certainly be.
So the conditions of the interim order knowingly were disobeyed. So they can't take the plea, sir. After all, we were waiting for the final judgment.
So there were
parties to the interim order. They had to obey the interim order. They cannot argue after that we had sufficient costs.
No, that's all right. That
scenario
will definitely be a case.
That scenario during the pendency of an interim order, where the conduct of the party is of a certain kind that is in violation of the interim order itself, will not permit that party to argue that there was sufficient cause not to pay.
That's right, Lords, but that's not the case here.
No,
So
that's
therefore-
not the case. So distinguish that case from the case you're arguing.
Yes.
That parties have obeyed the interim order, they have paid the installments as required by the interim order. Ultimately, the judgment went against them. You're arguing, sir, once the judgment went against them, this also is without sufficient cause, notwithstanding
yes.
that they may have paid the installments.
Yes,
without
yes,
sufficient cause.
that's what I'm contending.
So
That's precisely what I'm contending.
again, for you, there is no distinction. Again, for you, there is no distinction between a scenario where a person disobeys an interim order or a person who obeys the interim order. No
There's
distinction.
no question. The question of disobedience of the order is not relevant to sufficient cause or the payment of interest.
Why not, sir? When the matter is pending before a
Let me
court and
explain, Lord.
governed
If you
parties are
allow
governed by an
me-
order,
Kindly,
how
I'll
can you
just
not
allow me
test the
to-
phrase sufficient cause in light of what happens in terms of that order?
Kindly allow me to develop my argument, only then I can respond, my lord.
Mr. Dwivedi, if you want me to shut up, I will do that. I am posing these questions to help you further strengthen your arguments. But
No, Lord,
I
understand where this thing is going,
take
Lord.
your
It's not-
admonition well.
After
I'll now keep quiet.
After 50 years of practice, I understand, my lord,
Correct,
where
correct.
the
I'll take your
trend of
admonition,
the-
that's fine.
this query goes, my lord.
We bow down to your superior experience, sir. We'll
No,
keep
sorry,
quiet.
brother, I don't.
We'll
I
keep
don't.
quiet.
I'm sorry. Your lordship is misunderstanding me. I
Not
don't.
at
need-
all, not at all.
I
think
don't-
You're gently reminding us now. You better sit and listen for a while.
I don't claim at all any superior intelligence. What I'm saying
No,
is,
no. Please proceed now, whichever way you want. Please.
so what I'm saying is, my lord, that I don't claim any superior intelligence. But what I was saying is that when a judge puts a query to me, I understand, my lord, where the query is going, my lord. So when the lordship said, my lord, that 50% paid and is one situation, 50% not paid as per court's order is another situation. I'm trying to build my case in a different line altogether. I'm submitting, my lord, that interim orders passed by the court do not, my lord, by themselves lead to a waiver of any liability to pay interest in case of non-payment in time. That's what I'm trying to submit. And that's what your lordships have laid down in so many Supreme Court judgments, that interim orders of the court do not lead to a situation where the interest liability under the Act, which is compensatory in nature, restitutive in nature, because you have collected the money, you have used the money, you have kept back the tax money and utilized it. Therefore, you need to restitute and compensate.
Kindly proceed, sir.
Yes, sir. So I was pointing out at page 93 of the this interim order.
Yes.
Just see from the third line, lords, the top. However, each and every SSC in this group of cases shall undertake to pay the outstanding amount in installments with the current liability. That's one part. So the court is not only staying it, but my lord, clearly intending that the liability would revive. That may accrue pending disposal of these special leave petition. It is further made clear that assessee in this group of cases will have to deposit the outstanding taxes without penalty. You kindly also mark it. They are waiving the penalty, but they don't waive the interest. They are saying you will deposit the outstanding taxes without penalty. Please mark this expression. They don't include interest here. There is no intention to waive the interest. That's one. Now see, my lord, to attribute an intent to this, to the Honorable Supreme Court in this interim order, that they, my lord, intended avoidance of interest, ultimately, cannot be attributed because, my lord, kindly see the subsequent. It would be very anomalous. Look at Punjab and Haryana, where the act was struck down. The act, the second paragraph of the next SLP, it is pointed out that the levy of entry tax has been struck down by Punjab and Haryana.
Mr. Dwivedi, I don't know if this in page 93.
Yes, my lord.
My copy has one more line below that, what you are reading.
I think so, my lord, but
Till the next date.
Yeah, let him. He may want to interpret it. Do you have that line, sir?
no, in my copy it's not there, my lord. May I just... Sorry? Yes.
If an appeal is filed.
If an appeal is filed,
No, sir. Can you just continue reading? However, each and every SSC you were reading, correct?
just give me a
continue
second.
reading the whole thing, sir.
No, just it's completely, my lord, missing in my...
So I asked Mr. Sunil Mishra, he seems to have that line. You want to read it?
Your Lordship.
That however each and every SSC.
Your Lordship.
Just read it.
Till the next date of hearing, Your Lordship, sought this line.
I know, but you read it in continuity, then it will be. You start with however.
Your Lordship.
However, each and every SSC.
However, each and every SSC in this group of cases shall undertake to pay the outstanding amount in installment with the current liability that may accrue pending disposal of the special leave petitions. It is further made clear that the SSC in this group of cases will have to deposit the outstanding taxes without penalty. Till the next date of hearing, no recovery for the time being.
All right.
Yes, that's all right.
This is the line we meant. Right.
Yes. Since the court intended, therefore, my lord, to pass a further order with respect to the liabilities outstanding and recurring, therefore, my lord, they said that you first tell us what are the outstanding liabilities, and till that date, don't recover. So the only, my lord, stoppage at this stage is about recovery. Now, my lords, so that I don't need to come back again, your lordships have noted, and please note it once again, my lord, that in so far as Punjab and Haryana, where, my lord, the act is struck down. In our case, the act is valid, only one sentence in para 30, which is stayed. But here, the act is struck down, and yet in the middle, the court says that you will give an undertaking to pay the tax with interest. One and the same interim order, my lord, the court, in my respectful submission, my lord, ought not to be construed in a manner that one is obviating, my lord, or taking away the liability to pay interest, whereas where it has been struck down completely, the court is saying that you will have to pay interest ultimately. And that is supported by this without penalty. Had they intended, my lord, that ultimately interest will not have to be paid, they would have included without interest and penalty. The two concepts, my lord, the lordships are fully aware, my lord, and the courts are fully conversant with that. And they don't say that. Rather, my lord, they have been providing. Now, kindly come to the next order, my lord. First paragraph, the department has not be submitted. Then second paragraph, in this case concerning Bhushan Steel, we are not concerned with Bhushan Steel, but see what the court is doing now. and strips limited according to the department as on 30th September, an amount of so and so crore approximately is due and payable. See, the amount is which we indicated was found to be due and payable under the impugned law. At this stage, we are of the view that the assessee should deposit under protest with the department a sum of 7.50 crore out of 38 crores before 31st March 2010. This amount is calculated by us on the footing that assessee has already paid till date an amount of 8 crores. As far as current liability commencing from 1st October 9 is concerned, assessee will pay so and so. So liability, my lord, is kept alive, but the payment amount, my lord, as a workable arrangement has been reduced. Now, identically, please come to the next page. Kindly come to the next page, below the 99. Second paragraph, interim order passed by this court on 30th October 2009 to the extent indicated above stands modified. So the net result, my lord, is that para 30 is stayed. Liability court has asked us to indicate what is the total liability. 3, the court says outstanding liability is there, but you pay this much. That's a workable arrangement. And there is no intent expressed to, Lord, prevent these assessees from paying interest at the end of the day. Now, identical orders are passed, Lords, in Bhushan Steel, etc. And please come to the present matter bunch, which is at page 102. Having regard to the outstanding amounts in the list A and B mentioned above, we are of the view that each of the assessee, without prejudice to its rights, deposit with the department 1/3 of the outstanding amount indicated in list A and list B as on 30th September 09 before 31st March 2010. Each of such assessees will also continue to deposit with the department the outstanding amount on the basis of current liabilities. Please mark this sentence, brother. Whatever deposits are being curtailed and to be determined on the basis of the current liabilities. So every time, Lord, they have to file a full return as per section 3. So my respectful submission with regard to these two interim orders is, my lord, for your lordship's kind consideration, that by stay of para 30, the act which was already held to be valid by the High Court continues to operate with full force with respect to the petitioners before your lordships. That's one. Second, my lord, the court expressly says that the outstanding and current liabilities are the basis for the deposit of the amounts which are differing from case to case. So the liabilities are not shut out. Rather, the payments are based on the outstanding liabilities. Now, which can only happen, my lord, if the act is operating with full force. Otherwise, there is no liability. So if the petitioners wish to contend, my lord, that in view of the High Court judgment and the interim orders, there was no liability, my lord, to pay, I submit with utmost deference that there is no eclipse happening here.
We are not saying that. Liability ensues. And we are not saying that.
And third, my lords, The court clearly intends that penalty should be waived. Penalty, so it says outstanding liability without penalty, but it does not say without interest. There are three things. Now, my lords, kindly see the judgments of the court, my lord, which speak about the interim order. There's a compilation of judgments, my lord, which we intend to rely, my lord, if your lordship and अच्छा मुंडी को ओपन नहीं लगाया है क्या? And kindly come to page 5, Lord, Calcutta Jute case. Kindly have the first paragraph. The question raised in all these appeals is whether an assessee is liable to pay interest under Section 10A of the Bengal Finance Sales Tax Act 1941 on the turnover tax for the period during which the recovery of the tax amount was stopped by orders of the High Court. West Bengal Tax Tribunal answered the said question against the appellants and hence these appeals by special leave. Kindly come down to placitum D of paragraph 2. The High Court on admission of the writ petitions granted interim relief by injuncting the West Bengal government from collecting such tax on the turnover, but ultimately the writ petitions were dismissed. The liability of the appellants to pay tax on the turnover became conclusive and the appellants remitted the tax amount accordingly. But in the meanwhile, the government of West Bengal introduced yet another provision, Section 10A, by which interest at the rate of 2% was charged on the tax amount payable by the dealer during the period of default. So demands were made on the appellants to pay interest on the tax amount. Now kindly come to page 13, my lords. Paragraph 15, where JK Synthetics was relied upon, but the position here is explicitly distinguishable from the factual situation in JK Synthetics. Here, nobody had doubt that if Section 6B of the Act was valid, the tax was payable on the turnover. It was the constitutional validity of 6B. I'm sorry, brother. Are we on the same? Am I on the same page, brother, lordships? It was the constitutional validity of Section 6B which was challenged by the appellants in the earlier writ petitions before Calcutta High Court and which finally ended up in upholding of its validity. Hence, there was no question of the assessee waiting for the determination and the turnover as there was no dispute on that aspect. The fact that appellants questioned the constitutional validity of the charging section cannot be equated with a dispute whether the freight paid would also form part of the sale amount. It was a highly debated dispute which price amount would envelop the freight charges paid by the dealer, and until the controversy was resolved by the court in Hindustan Sugar, the dealers were justified in excluding the freight charges from sale price. It was for that reason the Constitution bench refrained from mulcting the taxpayer with liability to pay interest additionally. Appellants in these cases have never disputed that they are liable to pay tax on turnover under 6B, even while they focused on the virus of that provision. The tax amount which they should have paid as per 6B remained with the appellants during the entire period. Now, this is important, my lord, and I place heavy reliance on this, my lord. And they would have earned good profit with the amount. The state to which the tax amount should necessarily have gone was not able to utilize it for public purpose. When appellants had the advantage of keeping the amount of tax without paying it to the state exchequer, only because the High Court granted orders restraining the state from recovering the amount from the SSE, no act of the court shall cause prejudice to any party. The pristine doctrine couched in the maxim actus curiae nimium gravebit has ever remained a salutary and guiding principle. The contention that as the courts granted injunction restraining the state from recovering the tax amount as per 6B would raise a presumption that the court was then satisfied of the bona fides of the contention is too fragile for depriving the state of the statutory right of interest incorporated in Section 10A. Interim orders are passed by the High Court on variety of considerations, one of them being the strained financial position of person approaching the court. Merely because the court granted interim orders, it cannot be inferred that the court was then satisfied of a strong prima facie case for appellants. On the contrary, it is well nigh settled that there is always a presumption in favor of constitutionality of the legislative act. Presumptions cannot be other way around. So therefore, my lord, both on the principle of actus curiae nimium gravebit as well as restitution, the court says that this interim orders, my lord, will not have the effect of relieving the SSEs of the liability to pay interest. Now kindly have, my lord, the next judgment, which is paragraph 10 to 12, which is at page 14 on Oria Chemicals, a 3-judge judgment. Kindly come to paragraph 11, my lords. Page 20. The learned counsel for the appellant in appeals before us rely upon the portions underlined above passage as a decision supporting their contention that where the operation of government order is stayed, no surcharge can be demanded upon the amount withheld. We find it difficult to agree. In our respectful opinion, the underlined portions do not constitute the decision of the court. They merely refer to the fact that the board itself did not make a demand for surcharge amount in respect of the period covered by the stay under its own understanding of the effect of stay order granted by the High Court, and that it was justified in its opinion. The demand was, the court pointed out, in respect of period covered by the order of injunction granted by this court. This court held expressly that the grant of injunction does not relieve the consumers of their obligation to pay the charges. In this case, it was late surcharge, something like interest, at the enhanced rates, and therefore the demand for surcharge interest for such period is not illegal. The portions underlined cannot be understood as laying down the proposition that in respect of the period covered by the stay, no demand can be made. No such proposition can be deduced from the said passage for the reason that the liability for the said period was not at all in issue in the said decision. Unless put in issue and pronounced upon, it cannot be said there was a decision on the said issue. There was no list between the parties with respect to the period covered by the stay order of the High Court. If so, it cannot be said that any decision was rendered by this court on the said issue or aspect, as it may be called. We therefore agree with the High Court that Attorney Jiring cannot be read as laying down the proposition that the grant of stay of a notification revising the electricity charges has the effect of relieving the consumer petitioners of their obligation to pay late payment surcharge, stroke interest on the amount withheld by them, even when their writ petitions were dismissed ultimately. Holding otherwise would mean that even though Electricity Board, who was the respondent in the writ petition, succeeded therein, is yet deprived of the late payment surcharge which is due to it under the tariff rule regulations. It would be a case where the board suffers prejudice on account of the orders of the court and for no fault of its. It succeeds in the writ petition yet loses. The consumer files the writ petition, obtains stay of operation of the notification, revising the rates and fails in his attack upon the validity of the notification, and yet he is relieved of the obligation to pay the late payment surcharge for the period of stay which is liable to pay according to the statutory terms and conditions of supply, which terms and conditions indeed form part of contract of supply. We do not think that any such unfair or inequitable proposition can be sustained in law. It is a matter of no such proposition flows from Adoni Jennings. It is a matter of common knowledge that several petitioners word the stay petition differently. One petitioner may ask for injunction, another may ask for stay of demand, the third may ask for stay of collection of amount demanded, fourth may ask for stay of very notification. Such distinctions are bound to occur when large number of petitions are filed challenging the same notification. The interim orders made by the court may also vary in their phraseology in such a case. Take this very case. While the consumers had asked for stay of operation of government order revising the rates, those very consumers asked for an injunction when they came to the Supreme Court. Furthermore, as pointed out rightly by High Court, the orders of stay granted by High Court and writ petition questioning validity of notification were not uniform. In this case, then kindly leave the rest. Please come to the next page. After 5-6 lines, the words, or rather 10 lines down, it is equally well settled, italicized portion. It is equally well settled that an order of stay granted pending disposal of writ petition, suit or other proceeding comes to an end with the dismissal of substantive proceeding. It is duty of the court in such a case to put the parties in the same position they would have been but for the interim orders of the court. Any other view would result in the act or order of the court prejudicing a party bored for no fault of its and would also be rewarding a writ petitioner in spite of his failure. We do not think that such an unjust consequence can be countenanced by the courts. And please see, paragraph 12, Chamundi mopeds, the effect of interim order was spelled out. As has been pointed out by Justice S.C. Agarwal speaking for a 3-judge bench in Shri Chamundi mopeds, while considering the effect of an interim order staying the operation of order under challenge, a distinction has to be made between quashing of an order and stay of operation of the order. Quashing of order results in the restoration of the position as it stood on the date of passing of the order which has been quashed. The stay of operation does not, however, lead to such a result. It only means that the order which has been stayed would not be operative from that day. Now, in the instant case, it would be operative. If your lordship will stay the notification, then the notification is not operative. But if the rider which is coming in the way of the operation is stayed, then it starts operating. The stay of operation of an order, it only means that the order which has been stayed here, it is reverse situation. Now kindly,
Even given on the restitution and just reimbursement, it is still responsible, still cost. ये para 197 अलग होते जा सकते
Continue, sir, continue.
Now kindly have lost one paragraph of the next judgment, Indian Council of Enviro Legal Action, para 197 at running page 110. The other aspect which has been dealt with in great details is to neutralize any unjust enrichment, undeserved gain made by litigants. While adjudicating, the courts must keep the following principles in view. One, it is the bounden duty and obligation of the court to neutralize any unjust enrichment, undeserved gain made by the party by invoking the jurisdiction of the court. Two, when a party applies and gets a stay or injunction from the court, it is always at the risk and responsibility of the party. I'm sorry, Your Lordship, putting some query to me.
No, sir, please proceed.
Is always at the risk and responsibility of the party applying. An order of stay cannot be presumed to be conferment of additional right upon the litigating party. Unscrupulous litigants be prevented from taking undue advantage by invoking jurisdiction of court. A person in wrongful possession should not only be removed from that place as early as possible, but be compelled to pay wrongful use of premises, fine, penalty, costs. No litigant can derive benefit from the mere pendency of the case in court of law. A party cannot be allowed to take benefit of its own wrongs. Litigation should not be permitted to turn into fruitful industry so that the unscrupulous litigants are encouraged to invoke the jurisdiction of that court. The institution of litigation cannot be permitted to confer any advantage on party by delayed action of courts. I'm not reading, but Your Lordship may just note, at page 97, their Lordships have elaborated on unjust enrichment, and at page 98 on restitution. Page 97 is unjust enrichment, and at page 98 is restitution and compound interest. And the precedents on restitution are discussed at page 101. Nonetheless, the next judgment is Rajasthan Housing Board at page 127. Paragraph 4 to 8. Aggrieved against the restraint put on the appellants that they would not ask for payment of interest on the amount due from the complainants from so-and-so date to such and such date, the period during which the stay granted by the commission was in operation, have come up in these appeals. This court in a number of decisions have repeatedly emphasized that in view of the legal maxim actus curiae neminem gravebit, which means that an act of court shall prejudice no man, has held that the claimants allottees who have obtained stay will not be justified in seeking waiver of claim of interest over the areas which remain unpaid because of the stay granted by the court. And then they refer to some other judgments also to the same effect, including Kanoria Chemicals in paragraph 7. And kindly come to paragraph 8. style dress land has been quoted. Para 15 of that judgment, it is settled principle of law that as and when a party applies and obtains stay from the court of law, it is always at the risk and responsibility of the party applying. Mere passing of an order of stay cannot be presumed to be conferment of any additional right upon the litigating party. Then kindly come to page 134. Kindly come to page 134, Milords. This Haji Lal Mohammad BD Works, paragraph 7 at page 137. According to section 8(1)(a), simple interest at the rate of 18% per annum shall run on the amount of arrears of sales tax from the date specified in the subsection. It would thus appear that the liability to pay interest is automatic and arises by operation of law. The amount of interest on the date of payment of tax is not constant but increases from day to day. The amount of interest can therefore be not predicated till such time as the arrears of sales tax are paid, and it is consequently not possible to specify a definite figure in respect of the interest in the recovery of certificates. At the time the arrears of sales tax are paid, there can be no difficulty in finding the amount of interest which has become due, the amount of tax on which interest is to accrue, the rate of interest, the date from which interest is to commence, and the date up to which interest is to be counted are well known. It is therefore a matter of mere arithmetical calculation to arrive at the figure of interest. We find nothing in any of the provisions of the Act as may warrant making of another assessment order by sales tax officer regarding the amount of interest or making it obligatory for him to issue a demand notice in respect of the interest before sending the recovery certificate to the collector. Then kindly at para 10, argument has been advanced by Mr. Sen that interest on arrears of sales tax could not be realized for the period during which the recovery of sales tax was stayed. We find it difficult to accede to this contention because there is nothing in the language of 8(1)(a) of the Act which prevents the running of interest because of the operation of stay order. But this sentence is important because there should be something in the interim order which is preventing stay. And as I pointed out, the court said outstanding liability without penalty, but they never said without interest. If I may read this sentence again, Milord, we find it difficult to exceed this contention because there is nothing in the language of 8(1)(a) which prevents the running of interest because of the operation of any stay order. Indeed, the liability to pay interest is created by statute and sales tax officer has no discretion to grant any exemption. So, Milord, having placed these judgments, Lord, just two more, Lords, kindly have page 159. Kindly have paragraph 28 at page 168. Super added to all this is the fact that this court was dealing with a case where the High Court had finally struck down the revised tariff. Well, let's got this para 28, that page 168. Super added to all this is the fact that this court was dealing with a case where the High Court had finally struck down the revised tariff, but the said decision was reversed in appeal. In the present case, the appellant had obtained only an ad interim order of stay against the enforcement of the tariffs. There is qualitative difference in the two situations. Even if one were to take a charitable view of the legal effect of any direction of the High Court pending adjudication by the court, cases in which the High Court finally held the tariffs to be bad would, in our opinion, stand on a different footing than cases where the High Court party obtains an order granting interim order protection to it. While there is an element of finality in the case of a final adjudication by a competent court insofar as that court is concerned, an interim order can be vacated at any stage. The interim order may not even prevent a prudent party from paying the charges according to the revised tariff if it does not propose to take any chance and suffer any recovery of any additional amount on account of non-payment of the dues by the date stipulated for this purpose. This is very important, Lord, because and the fact that the court says that you may pay this does not mean, Lord, that the party is prevented from paying the full if it so wants to avoid to take the risk. Then 38 at page 170, it is manifest from the above that both on the question of restitution of the benefit drawn by party during legal proceedings that eventually fail, as also on the general principle that a party who fails in the main proceeding cannot benefit from the interim order issued during the pendency of such proceeding, this court found against the consumers and upheld the demand for payment of additional charges recoverable on account of the delay in payment of outstanding dues. Far from lending any assistance to the appellant, the decision squarely goes against it. So, my lords, the submission with great respect, my lord, what follows. And the last judgment, my lord, is JK Synthetics. Paragraph 23. It is therefore evident that whenever there is an interim order of stay in regard to any revision in rate of tariff, unless the order granting interim stay on the final order dismissing the writ petition specifies otherwise, on the dismissal of the writ petition or vacation of interim order, the beneficiary of the interim order shall have to pay the interest on the amount withheld or not paid by virtue of the interim order. Where the statute or contract specifies the rate of interest, usually interest will have to be paid at such rate. Even where there is no statutory or contractual provision of payment of interest, the court will have to direct the payment of interest at a reasonable rate by way of restitution, while vacating the order of interim order dismissing petition unless there are special reasons for not doing so. Any other interpretation would encourage unscrupulous debtors to file petitions challenging revision rate of tariffs and make attempts to obtain interim order of stay if the obligation to make restitution by paying appropriate interest on the withheld amount is not strictly enforced. Loser will end up with a financial benefit. So therefore, my lord, unless the court specifically says, my lord, that you don't have to pay interest, the court, they could have requested the Supreme Court at this stage of when the final matter was being decided and their appeals were being disposed of, that they should be relieved of the burden of paying interest. But they don't do so. Now, my lords, if I may sum up, my lords, my respectful understanding, my lord, of these judgments. One, my lord, that the filing of writ petitions and the passing of the interim order by the court by itself does not relieve a party from the statutory liability of paying interest. Number two, my lords, this requirement to pay interest is founded on salutary principle of restitution, compensating the state for utilizing, holding back the tax money and utilizing it. Three, my lords, the principle of actus curiae neminem gravebit also, my lords, is a very sound principle on which the orders of the court have to be interpreted according to that. So we cannot say, my lord, that while passing those two interim orders, the court was actually, my lord, allowing the operation of the High Court order and the stay of liability. That, my lord, cannot be a proper understanding in my respectful submission of the interim orders. The interim orders are simply a workable arrangement. So, my lord, they are simply a workable arrangement. 30 is stayed, liability is there. The payments which are being directed are the basis of those payment is the current liability. 1/3. So the fact, my lord, the court doesn't intend that in the event you lose, you are free from the liability of paying interest. So that's how, my lord, I understand, my lord, these judgments, and I submit that keeping in these judgments in mind, my lord, please construe section 7.5. If I may return, my lord, to section 7.5, my respectful submission is that this expression without sufficient cause cannot therefore mean, my lord, that because of some interim order passed by the apex court, which required deposit of a lesser amount than the full liability, that will amount to sufficient cause. My lord, sufficient cause has to be a cause which is extraneous, my lord, to the litigation. Litigation orders, my lord, are never, my lord, to be understood as sufficient cause. Otherwise, as the court says, my lord, that people will take chances. And they obtain interim orders, and finally, my lord, then we find, my lord, that they have to pay the entire tax, but they get away with the payment of interest. So sufficient cause has two elements are there, my lord, for this sufficient cause. Your lordship, may be pleased to note, my lord, that my respectful submission is that section 7.5 has two aspects. One, my lord, that the event which they rely upon should be preventive. And second, my lord, which means it should not be a result of their own volition in instituting litigation and obtaining interim orders. The second order, which was modification order, was at the behest of the petitioner, my lord, which they expressed their inability to pay because of passage of time and amount being huge. Therefore, the court, my lord, made a workable arrangement that you pay certain portion of the amount. Otherwise, the first order which was passed at our instance, my lord, that was that full liability will have to be paid. But the second order reduced it on the request of the petitioners. Therefore, section 7.5, sufficient cause, would, in my respectful submission, not include the litigative journey where volition of the petitioner is involved. And second, my lord, the cause has to be a cause which prevents them from depositing the whole amount. When the court says that you can deposit 1/3, it doesn't prevent them from depositing the full amount. It is up to the petitioners to take a chance. Either pay up the whole, avoid interest ultimately on losing, or pay according to that remission which has been given temporarily. And then, my lords, if you lose, you pay interest. You can't file petition and make your own action a sufficient cause. This has to be sufficient cause, my lord, has to be something like, my lord, when the government, my lord, imposes a COVID lockdown. Something extraneous is happening. Some major acts happen. Or there is an IBC situation where a moratorium comes in. They have to be extraneous. The law requires the principal officer to sign. If he is unable to sign because of serious illness, etc., maybe. I'm not trying to, my lord, be exhaustive about this sufficient cause. It cannot be, it's elastic term. The court will see from case to case whether it is or it is not, my lord, sufficient cause. But a litigation which is on account of the SSC's own volition, that in my submission, my lord, can never be a sufficient cause. You have taken a chance, you are entitled to institute a litigation, so you go by it. That's all right. But that's a chance which you have taken. That you cannot turn around later on and say that now this becomes a sufficient cause because in the process of the litigation, some interim order was passed which allowed me to deposit less. To deposit less means state cannot recover, not that you cannot pay. Now, as far as the cases which the petitioners relied on, namely JK Synthetics, the other JK Synthetics and Food Corporation, those are cases, Lord, where the act had been struck down and then it was not challenged. That was also the situation, Lord, in the judgment which my lords had passed, that is Bajaj case. These are cases, Lord, not involving a situation like this, where the portion, my lord, to which the state was aggrieved had been fully stayed. So those cases are, my lord, distinguishable. And there's one more thing, my lord, which Ms. Lakshmi Kumaran, my lord, had referred to a judgment of sufficient cause from Limitation Act. Now, my lord, so far as that is concerned, I submit, my lord, that sufficient cause in a tax statute and a sufficient cause, my lord, for having an access to the court for adjudication of rights, they will not proceed on the same basis, my lord. That is a case under Section 5 Limitation Act, and there the court says the threshold is low. Why, my lord? Because access to court is a fundamental right. Adjudication of rights by court is a fundamental right, and the limitation, my lord, bars adjudication by court. So therefore, Section 5, my lord, a low threshold. But in this case, this provision is a provision of restitution and compensation for the money which you have withheld and enjoyed, which is due to the state and meant for public purpose, use of public purpose. Therefore, my lord, Section 7B, 7.5 cannot be understood. The sufficient cause expression in 7.5 cannot be understood on the basis of judgments rendered in the context of Section 5 Limitation Act. The principle of purposive construction, my lord, is well settled. I need not cite any judgment on that. And so the mischief sought to be eliminated and the purpose for which 7.5 has been made have to be kept in view. And they are different from Section 5 Limitation Act. Here the purpose is compensation and limitation. And when the judgments consistently say that interim orders will not help in relieving you from this burden, then, my lord, I submit that sufficient cause be understood accordingly. That's my humble submission, Lord. I'm grateful to your lordship, Lord, for this indulgence, Lord.
Thank you. Thank you, Mr. Dwivedi.
And I'm sorry, brother, if I have given any wrong
Not
impression.
at all. Not at all. Every day is learning. So when will you like to, tomorrow or day after? Tomorrow? Tomorrow. Or
Tomorrow.
Day after.
Ballots,
Copy may be given also.
yes.
A compilation copy may be provided.
Tomorrow we'll do it. Tomorrow we'll do it, my lord.
I'm just saying, basically, we conclude. Whenever is the next, we conclude that.
Yes, give us.
I don't want any spillover.
2 days time. Tomorrow.
Tomorrow.
I think day after tomorrow will be better because one day despite
No, amongst yourself, you have decided. You tell me one day, I'll have it on that day.
Day after tomorrow.
day after tomorrow democratically. Let it be.
Day after tomorrow.
Yes.
All right.
2 p.m.
Is that all right with you, Mr. Dwivedi?
Yes, brother, but in case, brother, I'm held up, Lord, the lordships can proceed, brother. I had said whatever I had to say.
All right. Thank you.
But I'll try to be here. I will try to be here.
Thank you.
Memo.
at 2 p.m. my lord.
2 p.m. Thursday.
My lord.
All right.
I'm grateful.